Third list, any mentioning? Yes. Mentioning in the list.
Item number 185. Kindly maybe fixed on the 1st August. I have talked with the Mr. Somal Ganguly. He will appear. Today is
185.
185.
185. 185. Mr. Ganguly is appearing.
He will appear, Lordship. Very soon he will appear.
Acha, item 185 and 186. Let these two matters appear on 1/8/2026 at 10:30 a.m. Inform the other side.
So he will come. Just have talked and he will come.
Your Lordship,
Yes.
mention one matter.
Mention for?
Inclusion actually.
Inclusion for under what heading?
FMATIR
Under what heading? Hearing or application or what?
for admission.
No. Admission of what? First appeal.
Yes.
Question is.
It was filed long back in 2025 December. Till now.
The question is, what do you want? Any application is to be moved. Can application?
We have already moved two applications. One is for stay on the impugned order by railways, and other is for condemnation of delay.
Both are disposed.
No.
So let the applications appear. Section 5 application is to be disposed.
No, they have not been heard.
First of all, any applications are disposed.
No.
So let the applications appear. Give the CAN number.
CAN number 1.
Yes, if you have filed an application, the CAN number will be there. Give the CAN number, it will appear under the heading application.
Okay.
Intimate the other side.
Okay. I have
Yes, call the list.
My lord,
Yes.
mentioning a particular matter, very important, urgent matter. The difference between the two persons survey appeal here, file here, but the person concerned is that is the lady, and for a long time it is going on, my lord.
No. Question is, what do you want now?
No, I want to include in the list, my lord.
You want for what? Inclusion?
Inclusion, my lord.
What? Hearing matter?
No.
Then?
Then the first hearing, it is stopped, it is to 4-5 years.
Now what do you want? Inclusion under the heading what? Hearing?
Yeah.
Hearing of what? Second appeal or claim case?
First appeal.
Yes, first appeal.
My lord.
Okay, after 2 weeks.
My lord. My lord. Get to my lord.
Yes, call the list.
52 matter, I appear for the appeal. One and two can do twice. One and one is for restoration, one is for completion. My lord,
You are for the petition
for the
appellant.
appellant, my lord. My lord, there is two applications, my lord. The matter is unfortunate matter, my
Can 2 is for?
lord. Can 2 is
Section
for
5.
condemnation of delay for
Service upon the respondent is complete.
service is complete, my lord. In 2005, it has been served, my lord. Till then, my lord, nobody has appeared or.
Oh, have you filed your affidavit of service?
Yes, ma'am, I have to. Affidavit service.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondent in spite of service of notice. The affidavit of service filed be kept with the record. The application for under section 5 of the Limitation Act is taken up for consideration. This is what restoration application.
Restoration application.
This is CAN 2 is for?
Can 2 is for condemnation of delay.
Yes. What is CAN 1?
Can 1 is for restoration. Can 1 of 2015, my lord.
Yes, learned advocate for the appellant is present. None appears for the respondent in spite of service of notice. The application for restoration being can 1 of 2015
15.
and application under section 5 of the Limitation Act being can 2 of 2024
24.
is taken up for consideration. This is can 2 is for what? For restoration
Can do
limitation
for limitation.
with regard to this restoration application.
Restoration.
Hard learned advocates peruse the petition filed. Upon perusing the petition file, it appears that how many days delay?
Delay 71763.
Appears that the appellant has furnished the ground of not having any knowledge with regard to the order passed by the Honorable Division Bench dismissing the matter. Thereafter, upon obtaining knowledge, the appellant has filed this application. Upon considering the ground furnished for not being present on the date fixed and the ground for delay, this court is of the view that in the interest of justice, this application should be allowed. Thus, the delay in filing this restoration application is condoned. The order dated okay, it was dismissed by the division bench.
Division bench at that time these matters were before the division bench. My lord. So the
The entire matter was before the division bench.
at that time
Okay.
it was these matters were taken by division bench. My lord.
The order dated 26/8/2010 stands recalled, and this appeal FMA 273 of 2009 is restored to file. In the facts and circumstances, the appellant is directed to remove the defects within 10 days from today. Let this matter appear for report on (10/8/2026). Okay, 11/8/2026.
No, it was called defect here.
Both can 1 and can 2 stands disposed. Yes, you take steps to remove the defect, and it will be placed for report on that day.
File may be sent to department.
Yes, the file be sent to the department forthwith.
See, for the claimant respondents. So I have filed 2 applications. Lordship, in this regard, I have filed 3 folds of paper before your Lordship. Application 6 for Lordship, application for attainment of majority of applications are 5, 6, and 7.
Application 6, can 6.
Can 6 with regard to the factum of attainment of majority. 5, 6, and 7 already attained their majority, so kindly allow them to
So can 6.
can 6.
Yes, record an order. Learned advocates for the parties are present. The application filed by the appellants, all the appellants, is taken up for consideration. It is contended by the appellants that
Not
the-
appellants, respondents.
I'm
contended by the respondents applicants that the respondents number 5, 6, and 7 have attained majority. Have you enclosed the
Aadhaar card I have enclosed.
The Aadhaar card of the said applicants is annexed to this application. In the facts and circumstances, this application stands allowed. Let the majority of appellant respondent number 5, 6, and 7 be recorded.
Respondent.
The
Appellant, not I am
respondents applicants be recorded. The amendments be carried out within 2 weeks.
Second prayer is before your Lordship, the applicant number 1 and 4.
Yes.
respondent number 1 and 4.
Yes,
Lordship, some minor changes, Lordship, kindly come to page 4, paragraph 6.
yes,
If you kindly see from Chonchola allies Kalpana Muchi Ruidas to only Kalpana Ruidas Muchi. That's to and
from
Pinky.
Chonchola alas Kalpana Ruidas to Kalpana Ruidas.
Just this is
And
Pinky
Pinky,
Muchi Ruidas to Pinky Ruidas.
Achha, with regard to respondent applicant 1 and 4,
1 and
learned advocates for the parties are present. An application is filed by respondent stroke applicant number 1 and 4 to record some correction in their name. It is contended that the name of Chonchola alias Kalpana Muchi stroke bracket Ruidas be corrected and made as Kalpana Ruidas Muchi. Stop. Further, it is contended that Pinky Muchi Ruidas be rectified and corrected as Pinky Ruidas. Stop. Thus, this application stands allowed. Let necessary amendment be carried out in terms of paragraph 6 of this application, Can 7 of 2006. The amendments be carried out within a period of 2 weeks.
26.
Huh?
2026.
Yes, it Can 7 of 26. The amendment be carried out within a period of 2 weeks.
By the department.
Yes, yes.
Lordship, third full page, kindly you accept the paper that I have served.
The paper books file be kept with the record.
PCR with the record.
No, that is there,
With
okay.
with the file. Lordship, kindly fix any date, Lordship. I believe.
No,
this
no,
document has-
after, just wait for some time.
Lordship, kindly
It's a 2026 matter,
No,
okay?
no,
Oh, 16.
2016.
Anyway, let the amendment be carried out, I shall fix a date.
Lordship, it's just liberty
After
to
tweaks.
mention. After 2 weeks.
আচ্ছা ওখানে লিখে দেবেন তো ওই লাস্ট অর্ডারটা লিবার্টি টু মেনশন
After 2 weeks, malan any day.
লিবার্টি টু মেনশন আফটার 2 weeks after 2 weeks you mention
After 2 weeks, malan any date, malan.
no, just wait because there are many matters fixed mention after 2 weeks.
I am for the applicant.
Item for my lord, I am for the claimant respondent.
Yes,
My
54.
application, I have filed
It is an old
for the
matter,
withdrawal
my lord.
application.
If a LCR has come, my lord,
Yes,
if a-
What is this application? Can to
can do for withdrawal,
your application
my lord.
withdrawal are you challenging the quantum or the
My lord, I have challenging her. Several grounds is there, my lord. The several grounds is there, my lord, that if he.
how much was awarded?
There were 6 lakhs, my lord, plus. Just a minute. 6,77,000 something, my lord.
No, your ground of challenge is the quantum or the
Oh, yes, quantum, my lord, there, and my lord, the death certificate, the disability certificate has not been approved by the doctor, issued by him, and my lord, the vehicle was held on route permit, my lord, several grounds.
No, my lord, this
So, my lord,
disablement certificate issued by the medical board, 50%. It has been exhibited, my lord,
it's a which year case of
2027. 17,
Now he is-
2017, my lord.
LCI has come, my lord, the department.
Yes,
2007.
no, this application can 1 and can 2 these are all disposed. Can 2 of 2026 withdrawal.
Yes, yes.
Acha, record and order, learned advocates for the parties are present. An application is filed by the-
Copy of this, sir.
by the claimant respondents for withdrawal of the compensation awarded. The question is part compensation can be withdrawn. You see,
Yes, yes.
He also fixed his date of hearing, my lord, that.
50% disablement, my
if
lord,
the,
is circular, my lord.
if the challenge is only with regard to the quantum
Yes.
and the appeal cannot be heard out within a short period, then part of the compensation can be
But
withdrawn.
actually, my lord, if you lost it, my appeal will become infractor.
No, no, not entire compensation, only part compensation.
Just correct, my lord.
Our 6 lakh.
But he has a fixed
Yes,
date,
my
my
lord,
lord,
6,77,581 along with the interest, 7%.
But he has a fixed date of hearing, my lord. LCR has come, my lord.
But এই যে circular, my lord, the
Learned advocate, the claimant appeal respondents have filed application for withdrawal of the compensation amount. Stop. As the appeal is ready for hearing and the paper books filed, let this matter appear for hearing on. দেখুন date কবে দেওয়া যায়? 11/8/2026 at 10:30 a.m.
At
10:30 a.m.
silent paper.
Only,
The
I'm paying
paper books file be kept with the record.
only 2 lakhs, my lord, kindly be considered.
Yes.
Only 2 lakhs, my lord.
Anyway, let the appeal be heard out, okay, within a short period.
Yes, paper.
The paper books file be kept with the record. Hey, Cantor.
I'm appearing on behalf of the appellant insurance company. My lord will kindly fix up a date. My lord will kindly take it
What
up
are
on
these applications?
this application.
Your application?
No, not mine.
Must be my
Condition of
stay.
delay.
No,
I'm filing the paper book.
can one must be my application. I'm just checking. But I have already deposited the entire awarded sum before my lord's court. Can 8857 8857. Oh, can 2 is for appropriate order. That is for deposit of awarded sum on a later stage, my lord. After stay, there was a delay.
Anyway, that is
That
disposed.
has to be disposed of. If it is not disposed, my lord will kindly dispose it of because I have already deposited.
So if the entire amount is deposited, let
Yes.
the stay order be made absolute.
Yes, yes. And my lord will kindly take it up on 1st of August because this can be disposed of. It's an old matter. MSCC of 2012.
Yes, record and
Paper
order.
books are ready.
Paper book is I'm filing the paper.
Learned advocates for the parties are present. As the entire compensation amount is deposited, the ad interim order of stay granted earlier shall continue till disposal of this appeal.
My lord.
As the matter is ready for hearing and the paper books filed, let this matter appear for hearing on 1/8/2026.
My lord. My lord. All the applications are disposed of.
Yes.
Grateful, my
The
lord.
application stands disposed.
Paper book I have filed today.
Yes. The paper books file be kept with the record.
1 তারিখে fix করলেন for hearing. Grateful, my lord. হ্যাঁ কি আমি শুনতে পাচ্ছি না আমি পড়িনি কিন্তু অর্চনা দোলাই আমি কিছু পড়িনি অর্চনা
Yes, not today.
On the last occasion, my lord, I had taken time to file the substitution application, my lord. Difficulty on my part is the officer who will be affirming this application is out of station. She'll be coming back on,
Okay, not this week.
no, my lord, after 15th of August. She's in abroad.
Yes, learned.
My lord, I'm appearing on behalf of the respondent number 1 and 2, my lord. I've already filed an application, the withdrawal of the 50% of the.
This matter can be disposed of?
Any question is, have you challenged only the quantum?
Yes, yes, it can be disposed
now
of. That's what I told her. That
Now the question is, if you have challenged the
Yes.
quantum, if the
Let it
matter
be
cannot be
disposed of.
taken up,
Yes.
then part of the amount can be withdrawn.
end of August, my lord will fix it up. Matter can be disposed of. The entire matter can be
How much
disposed of.
quantum is there awarded?
12,86,000.
The entire matter can be disposed of. Why keep it pending?
My lord, already my lord respondent.
That is what I had
number
told my
has-
learned. Ek minute. That is what I had told my learned friend on the other day that let the matter be disposed of.
Yes, learned advocates for the parties are present.
আমাকে একটা
Uh,
legible copy দাও
On the prayer of learned advocate for
better.
the appellant, the matter stands
Yes.
until
End of August, any day my lord will fix it up.
11 তারিখে, হ্যাঁ? After 15,
After 15.
16 তারিখ দেখুন, 17 তারিখ, 17/8/2026
Lordship, deeply obliged, my lord.
hearing
My lord, my lord. Grateful.
at 2 p.m.
At 2 p.m. 17. Grateful, my lord.
Grateful.
হ্যাঁ
58 I appear for the appellant.
Yes, can
One only go. The
Have you served? Have you served the respondents?
My lord, I have served the respondent. They have appeared. They have filed their opposition. My lord, I am opposing, though I am not.
Okay, so let them appear. Today they are not appearing. Okay. I'm making it not today.
Only not today, my lord. Only not today.
Yes. Yes, not today.
Lordship, I am for the petitioner, my lord. Last petition, there is a direction for filing paperwork, my lord.
You are for the appellant.
Not today.
60.
Item 60, you are for the appellant. Let me see the last order. So trial court records have not yet been received.
I'm for the opposite party, my lord.
Okay. So paper book is to be prepared at your by you, but the trial court records have not come. So the matter was before the division time.
Reversion bench, lordship, it inadvertently appeared before the division bench. That is a remand matter, lordship. Thereafter, matter has been mentioned and came up before your lordship. Last everything, there is a direction to file paperwork. On can is also running, my lord, which is that order has been extended after the disposal of the said matter. That can recur to my lord also disposal. Injunction application.
Yes, record an order. Learned advocate for the parties are present. As the trial court records have not come and the paper books could not be filed, let this matter appear on 18/8/2026. The reminder, have you deposited the special messenger cost for the trial court records?
Yes, lordship, we have deposited.
You have deposited. Let a reminder be sent for sending the trial court records.
Lordship, the matter will come under the heading hearing, my lord.
No, under the same heading.
Lordship,
And because paper books have not yet been filed. Unless the trial court records come, you cannot file the paper books.
Yes, yes, we have served.
No, for the claimant respondent matter.
Children?
'61, who is for the appellant?
I am the appellant.
Yes.
Stay has been granted. I have deposited entire ordered amount. Let the appeal be fixed for hearing.
Or submitting the paperwork, my lord.
হ্যাঁ দেরি দেখুন ওই 12-13 দিকে ওই সময় দেওয়া যায় কিনা আর কি। আচ্ছা, let this matter appear under the heading to be mentioned on, okay, 3/8/2026. Thereafter, I shall fix a date. 3rd of August.
I'm submitting the paper.
The paper books file be kept with the record.
At the change of address of married couple.
My lord, 62 is insurance appeal. Pursuant to the direction passed by this honorable court, my lord, the entire awarded sum has been deposited. My learned friend is appearing on behalf of the claimants. My lord, there are 2 CAN applications before your lordship filed by my learned friend. It receipt the
The entire amount is deposited.
entire amount is deposited.
So whose application is this? Can?
This is the claimant's application. There are 2 applications. The respondent number 4 has died. So, Malad will kindly
Claimant respondent number 4.
Yes, Geeta Rani Mondal.
Yes.
Malad, I have already attached the death certificate, Malad. Malad will expunge her name from the cause list.
The years are already on record. Yes, and what is this application? Can 3?
Malad, Can 3, Malad, is my application for recording the address of respondent number 2, who is the married daughter. Malad, after marriage, her address has changed. I have already annexed her Aadhaar card. Let the Malad amendment be carried out in
That is respondent number 2.
Yes.
Rokshamoni Khan.
My lord.
Yes, record and order. Learned advocates for the parties are present. As the compensation awarded by the learned trial court is deposited, the identity order of stay shall continue till disposal of this appeal. The application Can 3 of 2026 is taken up for consideration. In this application, the applicant respondent number 2, Rokshamoni Khan, has contended that her present appellant has changed.
One disposed of
Present address has changed. Thus, the change of her address as contended in paragraph 5 of the application be recorded. The amendments be carried out within 2 weeks. The application stands disposed. The application Can 4 of 2026 is taken up for consideration. It is the contention of the appellants, respondents, claimants that the respondent number 4, Geeta Rani Mondal, died, leaving behind respondent number 1, 2, and 3 as legal heirs. In the facts and circumstances, let the name of respondent / claimant number 4 be deleted from the cause title. The amendment be carried out within 2 weeks.
Malad, I have filed a cross objection number 2 of 2025. Let that be tagged.
Okay, the cross objection filed by the respondents claimants.
Court 2 of 2025. Court 2 of 2025.
Be tagged along with this appeal.
Malad, I am filing the paper book. Kindly record.
The paper books file be kept with the record.
And Malad, kindly fix a date for here.
Just wait for some time. Just wait for 2 weeks.
63, I am appearing on behalf of the appellant insurance company, my lord. I have served. Can 1 is my application for stay and Can 2 is my application for condonation of delay. This is my affidavit of service. The owner, my lord, that is respondent number 2, has left without any instructions. And the claimant, my lord, they have received. He has received. My appeal is purely on quantum.
In both the applications?
I have served the condonation of delay application.
As well as?
No, only the condonation I have served. The owner has left without any instructions. So it's equal to good service, my lord. And the claimant.
So it has returned with the remark that
addressee left without any instructions.
Yes, record and order.
Since it's purely on quantum, my lord will dispense with the service upon the owner for the time being. My appeal is purely on quantum.
Okay. How many days delay?
Not much, my lord. I'll just indicate 31 days as per my calculation.
Learned advocate for the appellant is present. None appears for the respondent's claimants in spite of service of notice. However, with regard to service of notice upon the respondent vehicle owner, the registered envelope has returned with the remark addressee left
Without instruction.
without instructions. Thus, the service of notice upon the respondent vehicle owner is dispensed with at this stage. Upon perusing the application for condonation of delay, it appears that the appellant has furnished sufficient ground for the delay in preferring the appeal. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. The application for stay being Can 2 of 2020, Can 1 of 2026 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an interim order of stay of the judgment and award dated 23rd day of February 2026, passed by learned additional district judge, 6th Court Alipur, South 24 Parganas, in MSC case number 32 of 2008 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum as directed by the learned trial court within 5 weeks, excluding the statutory amount. In the event the entire compensation is deposited within 5 weeks, the interim order of stay shall continue till disposal of this application. The Registrar General ওটা করে দেবেন, হ্যাঁ? The appellant shall cause service of notice upon the claimant's respondents.
Number one, only one.
Number 1, personally through registered post as well as through the department by filling up necessary requisites. Liberty to mention after 5 weeks.
I'm my lord, grateful.
My lord, in item number 65, my lord, I am appearing on behalf of the appellant insurance company. My lord, there is only one can, my lord, which is for stay. My lord, I have already deposited, my lord, the statutory amount.
দেখি অ্যাপ্লিকেশনটা Yes, record an order. Learned advocate for the appellant is present. As the appellant has deposited the statutory amount of rupees 25,000, there shall be an interim order of stay of the judgment and award dated 22nd day of January 2026, passed by learned additional district judge, first track second court Malda, in MSC case number 294 of 2023 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum as directed by the learned trial court within 5 weeks, excluding the statutory amount. Stop. In the event the entire compensation awarded is deposited, the interim order of stay shall continue till disposal of this application. The appellant shall cause service of notice upon the respondents, both personally by filling up, both personally through registered post as well as by filling up necessary requisites through the department. There is an application for amendment.
No, my lord, there is only one application, my lord, it is for stay. My lord, can 1 is for stay.
Okay. No, the appellant insurance company shall cause service of notice personally through registered post as well as through the department by filling up necessary requisites and forms. The trial court records be called for at the special messenger cost of the appellant to be deposited within 2 weeks. Liberty to mention after 5 weeks. The ageta to kore deben, the trial court records. Yes, sir. In the previous order, I am also mentioned that the trial court records be called for at the special messenger cost.
66 Lordship, I am for the appellant. Lordship, I have filed one application for Lordship condonation of delay. According to Lordship, 134 days delay. Lordship, kindly condone the delay and fix the matter on 1st August because the only quantum is the issue. Mr. Ganguly is appearing. I have talked to Mr. Ganguly, his junior is present. Lordship,
So paper books have not filed.
no, that I have prepared that with me. Lordship, kindly record that paper filed in.
You are for the respondent insurance company.
I have just a copy of South.
Vehicle owner?
Because did not contest. Lordship, kindly see, it is recorded in the judgment. Page 3. Page 3 of the judgment, paragraph 3. Page
Yes,
3.
record an order. Learned advocates for the appellant claimants and learned advocate for the insurance company are present. The application for condonation of delay is taken up for consideration. Hard learned advocates peruse the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that the appellant has furnished sufficient ground for condoning the delay. Thus, delay in preferring the appeal be condoned and the appeal is admitted. Stop. As the respondent insurance company is present in court, service of notice upon respondent insurance company is dispensed with. Stop. Further, as the respondent vehicle owner has not contested the case, the service of notice upon the vehicle owner is also dispensed with. The paper books filed be kept with the record. Let this matter appear for hearing on 1/8/2026 at 10:30 AM. কটা পড়ে গেছে? হ্যাঁ, হলো না হলো ওই তো শুধু ফিক্স ম্যাটারই হবে আর তো কি নেই।
এই যে পেপার ওটা দিস। Lordship, on that day, just I am suggesting matter will appear on serially without mentioning.
Yes, 10:30.
All the matter serially will appear.
Matters fixed will appear under the heading fixed matter at 10:30.
All the matter.
My lord, I am for the appellant insurance company and it has been filed within time, only stay, and I have deposited statutory amount. This is my challan.
Yes, record an order. Learned advocate for the appellant insurance company is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an interim order of stay of the judgment and award dated 27/4/2026, passed by learned additional district judge First Track, First Court Alipur in MACC 171 of 2023 for a period of 5 weeks. The appellant insurance company shall deposit the entire compensation awarded, excluding the statutory deposit, before the Registrar General High Court, Calcutta, within 5 weeks. Stop. In the event the entire compensation awarded is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The appellant insurance company shall cause service of notice upon the respondents, both personally through registered post as well as through department, by filling up necessary requisites and forms. The trial court records will be called for at the special messenger cost of the appellant to be deposited within 2 weeks. The paper books be prepared on arrival of the trial court records. Liberty to mention after 5 weeks.
Good.
Lordship, I am for the appellant. I have complied with the learned court's order and the entire amount has been paid, Your Lordship.
Lordship, I am appearing for the Lordship
Whose applications are this? Can 2 and 3?
Can 3, Lordship, is my application, so it's application for expressly hearing. Lordship, I am filing the paperwork and
And
record
can
that.
2?
Can 2 is their application for condition delay and stay.
No, that is condoned.
The condone and Lordship also directed to deposit the entire awarded amount. They have completed the Lordship's order, deposit the entire amount. And also already my learned junior given that
Only the stay has to be made absolute.
yes, Lordship, delay condone.
Yes, record an order. Learned advocates for the parties are present. Learned advocates for the parties are present. As the entire compensation awarded is deposited, the ad interim order of stay shall continue till disposal of this appeal. The trial court records have come.
Lordship, no, here only the quantum is the issue, their appeal. So can be fixed on 1st August. So I've talked with Mr. Ganguly, it can be disposed of very short period.
This is a 2026 case. Why so urgent?
But Lordship,
So much urgency.
No, Lordship, kindly see the learned tribunal, there is some other problem. There is the appeal of the insurance company. But claim, I have not received any award. The claim was filed, Lordship, on Lordship, kindly see to the 22. So Lordship, can dispose of the appeal only the issue of quantum because of the order passed, they have obtained the stay order, they are enjoying the stay order.
No, this is a 2026. You see, so many matters are could not be taken up.
4 years ago.
No, claim of?
That is the insurance company's appeal, is not my appeal.
Achha. Paper books are ready?
Yes, Lordship.
Achha, let this matter appear on 1/8/2026.
My lord, item number 58, your lordship, has been made.
My lord, 58, my lord, both sides are present. Kindly only.
Do it on the next day. Be present on the next day.
For 2 and 3, my lord, Mr. Singh is appearing on behalf of the appellant, insurance company. My lord, he requested me to pray before my lord to fix this up on another day. He is not prepared in the matter. And one matter is also being taken up before the honorable division bench.
Okay, record an order.
I am filing in for my lord, supplementary paper book.
Learned advocates for the parties are present. The supplementary paper books file be kept with the record. Let this matter appear on
30th, 3rd, 30th July or 3rd, whenever, my lord.
30th July.
30th.
30th July.
30th July after that. 30-এর পরে মানে ওই সময়
30-এর পরে আর কি
সাপ্লিমেন্টারি পেপার বুক
ওই ফার্স্ট উইক অফ আগস্ট দেখুন
Two and 3.
13
my lord
8 2026 at 12:30 p.m.
my lord deeply obliged my lord
কবে হলো ডেটটা
13/8
12:30 না ওই নেক্সট লিস্ট বলেন এখন আর কিছু নেই তাহলে দেখুন অ্যাপ্লিকেশন কোনো ম্যাটারে বোথ সাইড
4 and
5 it's at 12 noon
12 oh 12 no
Lordship, 187, I know 187, I just forget Mrs. This appeal of the insurance company, it was fixed earlier occasion, but due to some problem, not taken up. Lordship, can you fix that? She will appear available on 1st August.
no how many matters you see so many old matters are pending
I believe Lordship perhaps more than 4
okay on the next day if time permits if both of you are here I will take it up
on 185 186
yes on the next on that day if time permits I shall take it up if both sides are present
you kindly at least make in the list if not
no it will remain in the list listed matter if both parties are present the matter can be taken up
কবে হ্যাঁ
after the matters are taken up if both parties are present and ready, willing, I'll take it up.
Lordship, of the record, I am submitting one thing. I believe food matter will be Lordship will have.
No, Mr. Singh has said that he will come.
Only other matter, Lordship kindly on that million.
I'm sure when matters are there, he'll be
Your
here.
learned friend will also come
I'll
on that
also
day.
come.
Okay, let us see.
I know.
matter.
4 and 5, my lord will kindly pass it over. My lord, Mr. Singh is appearing before Honorable Division Bench. Grateful, my lord.
Possible.
Pass.
Possible.
Pass.
Huh? Lordship, item number 6 and 7, Lordship,
My lord.
the appellant.
May I I am praying for not today. Item number 6.
Who is appearing? Item number 6 for the appellant.
Appellant.
Who is appearing for the insurance
My
company?
senior, sir. Senior, Rajiv Bhattacharya.
Lordship, several location matter was adjourned. Lordship, I am not opposing the adjournment, but it is very casual approach. Earlier 3 occasions, same approach, Lordship and entertained. This 6 times, Lordship kindly come to the order. Now he's sending a junior, Lordship will adjourn the matter. I will not bother. But Lordship, what is the and see what is the approach before the court? Just fix the matter at without any reason, assigning any reason and cause. Lordship, just kindly see the person is suffering 90% disability. 90%. Lordship, kindly come to the paper book. And Lordship, for my satisfaction, kindly allow me to place the case. For my satisfaction.
No, you are not the appellant. The appellant will
I'm
place the
also
case.
I have fresh appeal. I am also appellant.
No, let the appellant place the case.
Appellant. I am appellant.
This is your appeal.
Yes, it's my appeal.
No. Question is, you see, item 6. You see, you have filed the cross objection.
Not cross objection. The fresh appeal.
Oh, fresh appeal.
Yes, I have also paper and appeal. They have also paper and appeal.
They are also challenging the quantum. You are also challenging the quantum.
Lordship.
So anyway.
Lordship. Lordship, kindly come to the paper book for my satisfaction. Lordship, kindly come to the paper book.
So what purpose will be served? I cannot decide the matter.
No, Lordship, kindly note down that what my submission can be note down. Or Lordship.
No purpose will be served. You see, by hearing piecemeal way.
Now, Lordship, I am not bargaining with the court, but Lordship will fix the matter after 2 months, 3 months. 90%. They are enjoying the stay order. Very well, if you vacate the stay order, immediately they will come. Kindly vacate the stay order to them. One citizen appearing, vacate the stay order. Why they will enjoy the stay order?
2 p.m. You want a passover or just not today?
Not today, sir.
Not today, sir. তুমি করতে গেছো ভাই? My lord বলো.
No. Question is, you want not today, but
not today,
there is no assurance that tomorrow he will be available.
No, not a single day will be available, assured. Not a single day.
Has he come to court?
Yes, he has come. I've seen.
Engaged in another court?
That I don't know.
So shall I keep it at 2 p.m.? Can he come?
Take chance, Lordship, at least.
না তাহলে একটা ডেট ফিক্স করা যাবে না ওনার প্রেজেন্সে ডেটটা ফিক্স করব তাহলে
Lordship, kindly visualize the situation, Lordship. What is the appeal? Lordship, kindly, for my side, look, I make 2 submission. It is my entire submission. 2 submission I'll place. Lordship, kindly come to their memo and just 1 line submission. If Lordship will kindly enter me for myself, that it is fixed the matter. I mean, enter the night. I have studied the file. Kindly see the paper book. Kindly come to the. I will say Lordship also. I am kindly come to the paper book, Lordship.
No.
What is their grievance? What is their grievance? If their grievance tally with the evidence, then Lordship can be allowed their appeal. I have no objection. Here
okay, just record an order.
Kindly see the paper book for a moment. Kindly for my satisfaction.
No, purpose will not be served. If I am unable to decide, what is the use of seeing?
For my satisfaction, Lordship.
No, your
2 minutes, sir. 2 minutes.
Your satisfaction is not merely submitting before the court. Okay.
Pressing the court, I am not against the court. Lordship,
No. How much was awarded?
Huh?
How much was awarded?
Awarded, Lordship. Lordship, they are enjoying the stay order. That is the basic plea.
How much was awarded?
Awarded is, Lordship, 90%, 58, 91, 795.
58 lakh.
Yes.
Okay. To that they have challenged. How much are you claiming now in your cross objection?
My fresh appeal challenging that.
Yes, in your fresh appeal, how much are you claiming?
100%. And the learned tribunal considered 35% only. Whether the medical issue the certificate 90%.
Anyway, matter has to be heard. Learned advocates for the claimant appellant is present.
Lordship, matter can be make they are paid not today, then making only not today.
Time is sought for on behalf of learned advocates of
will happen,
the insurance company in the facts and circumstances. দেখি তো next week কবে ইয়ে করা যায়?
Lordship, fixed is unnecessary matter is fixing right, Lordship, but they will not appear. Unnecessary
I
fix.
don't know what is the reason of not appearing.
Nothing. Lordship, kindly fix the matter. Then next
If he can appear in other courts, what is the difficulty?
Lordship, kindly.
You all other advocates are appearing. What is the special reason for not appearing?
I don't know. Lordship, kindly remember my submission.
Yes.
On that, Lordship,
Okay.
same thing Lordship will found.
কত তো অনেক দেরি হয়ে যাবে এই
90% disabled, they are enjoying the stay order.
Second-
Lordship, kindly vacate the stay order. I file an application.
সেকেন্ড উইকে দেখুন তো
Lordship, kindly vacate the stay order.
Okay, 12/8/2026.
Yes.
Yes, please let him
Lordship,
appear on
not
that.
appear on that stay order will be vacated.
12/8/2026.
দাঁড়া
দেখুন তো কটা টাইমিংসটাকে দেখুন তো একটু ওই হ্যাঁ at 10:30 a.m. as the last chance.
Lordship, kindly record that. If not appear,
The event there is no appearance of the parties, the matter will be taken up in his absence.
plus 10:30. কি বলছিস তুই? Lordship, at 10:30 so many matters will be fixing. Lordship, kindly come reveal it.
আচ্ছা 12 তারিখে দুটোই কোনো ফিক্স আছে কিছু?
Let 10:30 be all right, Lordship. If Lordship other matter is fixed, kindly some privilege.
No.
Really, Lordship. আরে দাদা তুমি বসো না চুপ করে মামলা করছি জজের সাথে তুমি সবচেয়ে বড় কথা বলে যাচ্ছ বসো চুপ করে তুমি তোমাকে কোনো প্রয়োজন নেই তুমি বসো
Okay, the matter is fixed. Please.
Why are you arguing with me? No, suddenly this is your job. Lordship, what is this going on? I am arguing before Lordship. Now he is standing in people.
No, I am just asking him.
কিচ্ছু বলতে হবে না
আচ্ছা চুপ করুন
He Lordship is statute.
On 10/8/2026.
Standing in between.
No, he is giving me the clarification, not you. On 10/8/2026, the matter is kept at 10:30 and it will be taken up on that date.
If not matter, in absence, matter will be taken up.
Yes, in his absence, the matter will be taken up.
My lord, 4/5, my lord, let me take my chance at 2 p.m. my lord. Password.
Yes, when Mr. Singh comes, you inform me.
My lord.
ওখানে গেলে আবার সময় লাগবে এখান থেকে No, has there any chance to come
Yes,
by
yes.
12:30?
By 12:30, I do not know.
আবার অদূর থেকে আসতে হবে তাতে তো এখানে থাকা ভালো 2 p.m.
তিনটে ম্যাটার আছে
My lord, let me take my chance if Mr. Singh comes, my lord. That's
Okay, let us see up to 1 p.m.
my lord, deeply
এখানে
obliged.
থাকছি আর কি
deeply please.
একটার সময় না আসলে তাহলে আর করি
I'm
All the-
sorry, my lord, for keeping my lords waiting. My lord.
Anyway,
sorry.
yes, yes.
Note item 4 and 5. Note 4 is the appeal of insurance company and 5 is the cross objection filed by
I
me.
heard this matter earlier
Lord, my lord had my lord. And
regarding injury, disablement.
my lord, my lord, my lord.
So,
Lord, it's
I have heard it at length.
my lord had, my lord had. My lord, I'll not take more than 5-7 minutes. My lord, I'll just
That Rajkumar case you have already relied upon.
yes.
Anyway,
My lord, as my lord recollected, my lord, it is an injury case. One 38-year-old businessman, Sheikh Qasim.
yes, you have relied upon the business income also.
My lord, my
Whether
lord.
business income has reduced or not.
I'm
That you
grateful to your
relied.
lordship. I'm extremely obliged to my lord. My lord, this Sheikh Qasim, my lord, suffered an injury. He was a businessman, my lord. He was in a clothing business. He had a shop, he said. My lord, learned tribunal judge, my lord, awarded a principal sum of rupees 42,47,160 with interest. My lord, I have secured this entire sum with interest before your lordship's court. My lord, the injury was the fracture. My lord, this is not a case of amputation. The injury was fracture injury. My lord, one leg and my lord, this collarbone or my lord, the shoulder bone. These were fractured. However, my lord, the government hospital is stated 85% disability. 85. My lord, these are admitted facts. These are on record.
Yes.
My lord, learned tribunal judge considered functional disability at 50%. 50.
Yes.
And on that basis, my lord, assessment was made. Victim's annual income on the basis of income tax return, my lord, was taken note of. And my lord, then Sarla Verma Pranay Sethi, future prospect, everything was granted. Loss of income, my lord, as I said, on the basis of functional disability of 50%, my lord, 50% loss of income was considered.
There was no amputation, but as per the report, disability certificate, it is 85%.
Lordship, yes, yes.
So, tribunal considered the income tax return
My lord,
as the disability certificate.
Lordship, but assessed loss of income at 50%, 50. Functional disability 50% and corresponding loss of income 50%.
So the income tax return was filed for the corresponding year.
This is what, yes, for the corresponding year. This is where I will be joining issues against the award passed by the tribunal. First of all, the claimant's evidence, the injured claimant's evidence, who came to the court. That is said, page number 7.
Yes, page 7.
Page 7. It starts from page 7.
Yes.
Page 7 is affidavit in chief. It goes to page number 8. The last sentence of page number 8, I claim rupees 35,37,000. This is what he is claiming in evidence.
35,37,000.
Learned tribunal judge has already granted 42 lakhs.
35 lakh is where?
The last sentence of page number 8.
8.
Number 11. Page 8, yes.
Page 8.
Evidence started at 7.
That is, page 8 means that is PW6, not PW6.
No.
Okay. Actually, there are two page marking.
At the top middle,
Yes. I claimed. You see,
yes,
in one page it is in the lower portion, the other is in the upper portion.
I'm thankful to my lord. My lord has seen, my lord?
Yes.
He is claiming 35 lakhs. He has got 42.
Yes.
This evidence is further substantiated by the claim application at page number 2.
Claim application, page number 2.
Page number 2, my lord.
So same prayer,
Same
35
prayer,
lakh,
my lord, clause number
37,000.
22, clause 22, page 2.
Clause 22.
Page 2. It's the very beginning. My lord.
Yes, 35 lakh,
My
37,000.
lord, so he asks for 35. Before the court again, my lord, he prays for 35.
Yes.
Then, my lord, I had taken your lordship, my lord, to page number 7, page number 8, page number 9. Yes, my lord, the affidavit in chief.
Page number 9.
Just continuing, my lord, the claimant's case.
Different witnesses.
No, my lord, page number 9, the Sheikh Qasim Ali, the injured victim. My lord, I'm only on the victim.
Okay.
Page number 9, my lord, and then,
yes, chief.
yes, my lord. And then page number 10.
Page number 10, yes.
Lordship, page number 10 is the cross-examination.
Yes.
My lord, last 4 lines, if
Yes, there are 12 employees. There was 12 employees.
I have submitted IT return before the authority. I filed document that I am totally disabled, not the fact that the accident did not take place. My lord, in this page number 7, 8, 9, 10, my lord, he says that he had a garment shop. He had a 12 number of employees. Nowhere, my lord, it is stated that the shop is closed. Or the shop is not earning anything. My lord, that is the reason. That is the reason that what I say, the loss of earning is not to the extent of 50% what learned tribunal judge has assessed. Your lordship knows, I did not tell your lordship, why one comes before the tribunal, in these accident cases. So that, he is indemnified for the losses, current loss, and for entire future loss, what he has suffered or what he would be suffering. These losses are divided into 2 broad structures. One is pecuniary, one is non-pecuniary. Lordship knows that, my lord.
Okay, loss of earning capacity was estimated as how much?
50%, 50.
No, yes, quantum, that is...
My lord, that is 36 lakhs, 41,400. The award of learned tribunal starts at page 22.
36 lakh.
Lordship. And then non-pecuniary, my lord, conveyance charges.
Non-pecuniary, you see, the court has nothing to say.
Lordship.
Medical expenses and pain, sufferings and all those.
Yes, yes, my lord is correct. My lord, 36 lakhs.
Non-pecuniary.
Lordship, my lord, 36 lakhs odd were granted for loss of income.
Yes, yes. 36 lakh, 41,000.
I'm grateful. And then balance 6 lakhs odd, my lord, were for non-pecuniary, and my lord, 50-60,000 medical expenses and ambulance charges.
Yes, whatever is there.
Lordship,
is there.
lordship. So, my lord, this is the sum and substance, my lord. I say, when this shop was not closed, as per his own evidence, when the persons were working, then how come this 50% loss of entire earning capacity, including future prospect, 40% further added? My lord, this was excessive. My lord, this is one part. My lord, this appeal is on quantum only. And my lord, second part, my lord, I'll invite your lordship to this income tax return of this victim.
That is page.
My lord, income tax officer came before the court. My lord, he gave evidence at page number 21.
That is his claimant's witness.
Yes, yes, PW 11, page 21, income tax officer.
Yes.
I'm the inspector, is my lord there?
Yes.
I'm the inspector of income tax. I've come before this tribunal after receiving witness. This is the copy of income tax acknowledgement. Assessment here 11-12. Lordship has taken note of the date of accident, that is 26 June 2015, 1-5. My lord, the Nanda number 7 showing gross income of 2,54,000, net income. This is the copy of the income tax acknowledgement for the 12-13. We are not concerned. And the net income is the same. This is the copy of the income tax assessment here 13-14. We are not concerned. Under number so-and-so showing gross income of 2,80,000 and the net income is so-and-so. This is the copy of income tax acknowledgement written for the assessment year 14-15. My lord, he died in June 2015. Income tax return for the year 2014-15 under so and so, showing gross income of 3,46,800.
So prior to this death, what was the income?
My lord, 3,46,800. Your lordship will kindly come, my lord, to page number 133. My lord, I'll just show the corresponding tax return. Page 133. Is my lord there, my lord? Page 1. I'm sorry.
Yes.
Page 133.
Yes.
Right in the middle, my lord, is the receiving of the income tax department.
Yes.
This receiving is 15th June 2015, the rubber stamp.
Yes.
He died on 26th June 2015. So, my lord, before the injury, this was the last income tax return.
Yes.
The last income tax return, my lord, shows the net income, my lord. It is at page number 139. This
133.
My lord, I have shown your lordship 133. My lord, I'll show the amount now. The same income tax return. It continues up to page number 139, my lord.
Yes.
My lord, the net income herein, my lord, as per the evidence of the income tax officer, which was at page number 21, I had shown to your lordship, my lord, this is 3,64,255.
Page 139 is 3
My
lakh.
lord, page 139, my lord, is the 2014-15, and my lord, at page number 130.
Tax paid is 12,000.
Yes, my lord. Page 133 also shows the income. My lord, your lordship had earlier seen page 133, the receiving stamp.
Yes.
The very first column, my lord, 01 gross total income, 346,800 at page 133.
133. Yes, that is.
My lord, in the box.
Yes.
Item number 1 with the black boundary, B1 gross total income.
3,46,800.
I'm grateful to your lordship. My lord, so immediately prior to the accident, this was the gross income, 346,800. Learned tribunal judge.
Income is
346,800 gross.
Okay. Prior to accident.
Prior to accident. Learned tribunal judge, my lord, has taken this income.
Yes.
To be the income of the victim per annum. And on this income, 50% was, my lord, deducted as functional disability or loss of earning capacity. Now, my lord, what I say after what happened after accident. My lord, your lordship will kindly, my lord, for my take trouble of coming to page 21 again. The evidence of income tax officer. Page 21.
21. This person died when?
My lord, he suffered injury on 26th June 2015.
Yes.
Just 10 days before that, he filed this income tax return.
Anyway, the claim case is of 2016.
Yes.
Yes. So
Well,
this
now,
is a deposition of PW11.
Yes, my lord, PW11 income tax officer.
Yes.
My lord, I had shown to your lordship in the middle, my lord, that for the assessment year 2014-15, it is gross was 3,46,800. My lord has seen that that annexure. Your lordship, the next sentence, net income is 3,16,000. Next sentence, this is the copy of income tax acknowledgement return for the assessment year 2015-16. This is the next year after the accident. 15-16, showing gross income of 3,64,000. My lord, income next year has increased. It has become 3,64,000.
Okay, 2000. This is 14-15. Net income was 3,16,000.
Lordship.
And
so, my lord, even assuming gross
net income is 2,46,000.
Lordship. My lord, your lordship, my lord, I am on gross, my lord, just to see what was the total sale of whatever it was, my lord, of the shop. The gross in 2014-15 was 3,46,800 in 14-15. Immediately 10 days before the accident, I had shown your lordship, my lord, the annexure at page 133. And after the accident, the next year after the accident, for 2015-16, my lord, the gross income has gone up to 3,64,000. This is the evidence of, my lord, this income tax department.
Yes, yes.
My lord, unfortunately, this income tax return is not annexed here. I do not find it. in this paper book, which shows that it has gone up to 3,64,000, but the income tax officer says so. We cannot dispute that because this is what
net income, he stated net income 2,46,000.
Net income 2,46,000. Milord, what is happening? Milord, he says he was owning a sari shop. Milord, I sell 100 saris for the profit of 20 rupees. Milord, I get, Milord, 20 rupees into 100, Milord, 2,000 rupees.
Yes.
Next year, Milord, I sell, Milord, 120 saris for the profit of 10 rupees. My sale has increased, gross has increased, but my income has come down. Does it mean that I was not able to work? I've sold more saris, but I reduced the quantum of my profit. But my selling is not being disrupted.
After that, any other income?
Milord, after that, Milord, then to Milord, the story comes up. This page number 21, this officer says that this is the copy of income tax acknowledgement for the
Gross
assessment
income
year
89,123.
16-17. Here the income has been reduced 89,123. It was filed much after, Milord, the claim case was filed.
That is 2016-17.
Lordship. But Milord, after 14-15, the next evidence is, Milord, the income or the sales rather has increased. So, Milord, as far as the working is concerned of the shop, Milord, there is no deterioration of that. Rather, Milord, the gross has increased. That is why, Milord, Milord, at the very instant I stated, Milord, that whether the functional disability of the person has reduced or not, the sale of his sari shop has increased. The gross income has increased. And this is entirely business income.
That is up to last 2016-17.
Lordship, 16-17.
No
I'm on
income
that.
tax return is filed 2017-18.
Yes, Milord. 17-18, he has shown that there has been a reduction. 89,000 or 90,000. These are, Milord, these two returns are not annexed to this paper book, or rather they were not filed. I do not know.
So
but
not filed.
Not
As
filed.
per the authority, not filed.
As for the authority, not filed, Milord. Milord, but yes, Milord, he says these documents are marked as Exhibit 24, 24A, 24B, 24C, and 24D. No income tax return for 17-18 has been filed. Milord, for 17-18, the time had not matured by the time this evidence was given. This evidence was given, Milord, on 20th March 2019.
Okay.
Return is to be filed by 31st March.
20th
without late fees.
2019. So far, 17-18, that yes, that could have been 17-18.
The last sentence that the returns were not filed for 17-18.
Yes, 17-18.
Milord, the 17-18, the time was still due when this evidence was given, even without late fine. So, Milord, what I am on before your Lordship today, the claimant does not state before the court that my shop is closed. He says there were 12 employees. He does not say that the business has come to a standstill. Rather, the income tax authorities come up before the court and says that the last income tax return before the accident, there is a jump in the next income tax return after the accident. And in any event, there is no admission on the part of the victim that there was any loss of income. He does not say so before the court. Milord, this was the main issue before your Lordship. So what I, Milord, was praying before your Lordship, Milord, as far as, Milord, the loss of income, the pecuniary loss, on the face of it, there is none. So at best, your Lordship will, Milord, consider, Milord, 20% or 25% loss of, Milord, income. Milord, I would not dispute that. But this 50% loss of income for the rest of his life, when the shop is not closed, there is no evidence, Milord. When the employees have been, Milord, retrenched or Milord, have been thrown out of the, Milord, the shop, there is no evidence to that. Milord, verbal submissions would not do. Milord, so when it is running, or when, Milord, the employees are there, when the shop is showing on the face of it more sale than the last year, Milord, there was absolutely no loss of, Milord.
On the subsequent year.
Milord, on the subsequent year. That is there. And that is by the income tax officer. And that is their evidence. So that is why, Milord, I was...
This person died when, in which year?
Milord, he did not die.
Oh, he did not.
He did not die. Milord, he is still there. He came before the court to give evidence.
No, thereafter, during pendency.
Milord, no, he did not die. He is still alive. I believe, I mean, Jani, he is still alive. Milord, he is still alive. He came before the court. He gave evidence, Milord. And the injuries were fracture injuries.
Is it that he, without any escort, he cannot walk?
Milord, the certificate says that he requires an escort. Milord, I'll show the certificate also.
Yes, yes.
Milord, the certificate is at page number my lord, 77. Thank you.
Yes.
My lord, this column number 1, he is physically, orthopedically, my lord, disabled. My lord, what is written by hand, if I have read it correctly, it says post-traumatic, post-operational pain, deformity, and weakness of left lower limb. Patient cannot walk without support.
And he cannot travel without assistance of escort.
Yes, escort allowed, it says. Yes, column 7, escort allowed. My lord, this is there. But my lord, your lordship will see the extent of injury. If I can read it again, my lord, post-traumatic, post-operational pain, deformity, and weakness of left lower limb. So, my lord, this certificate is confined to left lower limb.
Yes.
My lord, whatever, my lord, the spoken verbally or whatever, my lord, is given there in the evidence, if the certificate on the basis of which, my lord, they have come to the court, if we rely upon that, that states that this deformity or this weakness or this fracture injury was confined to left lower limb. It does not speak about any other injury anywhere else. But, my lord, as far as the doctor is concerned, my lord, the doctor of this, my lord, hospital who came before the court, Ulveria SD hospital, my lord, he was also before the court. Let me just show, my lord, what he has also stated so that it is clear before your lordship. This is at page number 14, 1-4. But this is the last evidence. I will not trouble your lordship with further evidence. There were 11 witnesses on his behalf. 11. Lord, I'll be showing only 2 or 3.
Yes, page 14.
Page 14. The evidence of the doctor. My lord, at the top it is written 6 and below that it is written 14.
Yes.
My lord has got that, my lord. I am now attached to Ulveria Hospital. This is a disablement certificate by the medical board. I was present at the time of issuance of this certificate. I am the orthopedic surgeon. My signature appears. I know the signature. Medical board assessed disability to 85%. Certificate has been issued after following the rules. The patient is unable to move normally. My lord, yes, he is unable to move normally. My lord, even if he limps, I take that. But he is limping, fine.
That is, he's unable
Disablement
to,
certificate is
and
marked.
without cannot walk without support. That means some support is necessary.
Yes. I agree to that. I agree to that. It is not that he is bedridden. It is not that he cannot do his work. It is not that he cannot move. It is that he cannot move normally. The patient not cross. The patient is suffering from trauma following operation. He had paid deformity and weakness. He has paid. He had claimed deformity and weakness of both lower limbs. The patient cannot walk without support. I cannot say as to why the injury mentioned covered under Schedule 1. I cannot say at this stage the disablement certificate issue following the calculation because the calculation sheet is not annexed.
So is there any provision for review after 10 years?
No, it is not written. In their certificate, it is not written with regard to the review. My lord, this deformity or this injury, as per the evidence of the doctor and as per the medical certificate, disablement certificate, what they are relying upon is confined to one limb, lower limb. My lord, this is what the evidence is. He cannot move normally. I understand he cannot move normally, my lord. This is not a case of amputation. My lord, he's having trouble in walking. He might be needing a crutch or any support. I agree to that. Does it mean that his business has closed when there is no evidence to that?
So 50% loss of earning.
50%, 50% loss of earning is a huge earning, my lord. In the context of this, my lord, when we consider, my lord, 85% disablement, when, my lord, both legs are amputated, my lord, one leg, my lord, this is not under schedule. of the workman compensation. These are fracture injuries. My lord, 85% injury. My lord, if I show my lord the schedule, my lord, then this is amputation of 1 lakh and 1.5 lakh. And my lord, can we compare these two? My lord, the maximum deformity or the maximum disablement is 100%. One cannot be more than 100%. And my lord, when is it 100%? 100%, my lord, one is in absolute vegetative state. পুরোটাই ধসে গেল. That is, my lord, 100%. Here, my lord,
stated 85% lower limb.
Yes, my lord, that is what. Why? That is what.
Development of lower limb.
My lord, this is where I
Not
join
entire
issues.
body, not
entire. I'm extremely grateful.
Yes,
to you,
not
Lord.
entire
This is not entire body. This is confined to one lower limb. This is what the doctor has said, and this is what the certificate has said.
And no amputation.
No amputation. No.
But only thing is the review is not there after 10
Review is
years.
not there. My lord, I take it that, my lord, 85% of the one lower limb.
He will continue throughout his life.
He will continue through. I go to that extent also, my lord. Fracture injuries, we all know in our family, to our near and dear ones, my lord, a lot of people suffer fracture injuries. Do they continue, my lord, that suffering for the rest of their life? My lord, some weakness is there.
In all cases, this disablement certificate is not there.
Yes, it is.
May be
It is here.
30%, it may be percentage, it may be there.
But my lord, why I am saying, when somebody comes to the court and taking advantage of that disablement certificate, one claims for compensation. My lords are here, my lord, to decide what should be the gist.
Anyway, that decision is to be followed.
Lordship, the decision is to be followed.
My lord, of Ajay Kumar's case is to be followed.
My lord, Supreme Court, one of the latest decision, my lord, has said that when the injury is confined to one particular limb and not to the entire body, which is in our case, my lord, then the percentage of disablement is to be reduced by 1/4. My lord, it was followed by our Honorable High Court, Honorable Justice Ananya Bandyopadhyay, had following the Supreme Court judgment, has reduced this functional disability or loss of earning capacity to 1/4 of the assessment. My lord, I'll just show these two judgments and then I will not trouble your lordship. My lord, the way the Supreme Court has said so. My lord, there are hundreds of judgments. I will not trouble. I'll just give two judgments, my lord. When the injury is confined to one particular part of the body, my lord, then the percentage of disability with regard to the whole body, which is equivalent to the loss of earning capacity, is to be brought down to 1/4. One second. বিভোর আছে তোর কাছে? বিভোরটা আছে? বিভোর আছে? তুমি একটা জসাবকে দাও না প্লিজ। আমার কপিটা কোথায় গেল? বার করেছিলাম, মিসপ্লেস হয়ে গেছে, পড়ে গেছে। কোনটা বলেন? বিভোর না? বিভোর। হ্যাঁ, এক সেকেন্ড। হ্যাঁ, ইউপিএসসি। হ্যাঁ, ইউপিএসসি ভার্সেস বিভোর। Not one judgment, not perhaps it's missing from my. My learned friend has got it. Not, I'm just handing it over. Your lordship will consider. I'm thankful to him, my lord. He's been extremely cooperative. I must appreciate.
So anyway, so that Supreme Court judgment and Justice Bandyopadhyay's
Yes, my lord. Supreme Court judgment. My lord, this is the judgment I'm relying upon. My lord, in this case, my lord, this is against, my lord, the injury was confined to, my lord, one lower limb.
Yes.
Tribunal granted 4,24,000. Paragraph 1. UPSC filed this appeal seeking deduction of compensation by challenging the common judgment.
Okay. Yes.
Wherein the appeal filed by the corporation, my lord, in a claim petition filed by 166 was dismissed, and the appeal filed by the claimant seeking enhancement of the compensation was partly allowed. Compensation was enhanced from 4,24,000 by the tribunal to ₹30 lakh. My lord, tribunal granted 4 lakh.
So these are the decisions relied by you.
My lord, I'm only relying one judgment. This
No, you are so learned friend is you are relying upon all these three decisions.
My lord,
This is your written notes of argument.
this is written notes. Argument.
Okay.
So it will be submitted, my lord. So my lord can make.
My lord, he will in his argument he will place, my lord. But my lord, why I rely so? My lord, in page number 2, paragraph 1, tribunal granted, my lord, the first paragraph, my lord, the third line.
Page 23.
My lord, second page, page number 2.
We have heard the learned advocates.
No, my lord. Yes, my lord, no, at the top, my lord, before that. My lord, dismissed and the appeal filed by the claimant.
Uttar Pradesh Road Transport Corporation.
Yes. My lord, I am at page number 2, before paragraph 2, at the top, my lord, top 3 lines.
Okay.
My lord,
partly allowed and the compensation was enhanced.
I'm grateful. From ₹4,24,000 as awarded by tribunal to ₹30 lakh, by High Court. The tribunal granted 4 lakhs.
Yes.
High Court made it 30 lakhs.
Yes.
It is a case of injury.
Okay.
The injury is shown at page number paragraph 12 and 13, if your lordship kindly come to 12 and 13. The important question is, my lord, there.
Para 12.
Page number 12, para 12. Internal page 12, para 12.
Internal page 12.
Before, this UPSC judgment.
Yes, page 12.
I'm grateful to your lordship. My lord, the important question is, my lord, there. The important question which arises in this appeal is the percentage of functional disability suffered by the claimant because of the injuries in the accident. Applying the method of assessment as extracted from the judgment of Rajkumar, it can be seen that the tribunal as well as the High Court both erred in arriving at the functional disability suffered by the injured claimant. The tribunal considered the functional
paragraph
disability.
next comes the case of United. I think.
No,
this is UP. That UP Road Transport Corporation.
Yes, my lord. I am at UP Road Transport Corporation. That judgment. Internal page 12 of that judgment.
Internal page 12.
My lord, at the bottom it is page number is written internal page 12.
Running page 33.
Or running page 33.
Running page
33, 10, 30. For us, is on 34.
Yes, paragraph 12.
You ought to before they come to paragraph 11 as well.
Yes.
Paragraph 11. Now, considering the issue at hand, it can be seen from records as noted here in above, the claimant runs a textile business under the name and style of so-and-so. Business is continuing. Therefore, it can be seen that the claimant was having his own source of income and he would not lose the same because of injuries suffered by him. And therefore, we are of the opinion that claimant is not entitled to future of prospect. Then paragraph 12. The important question which arises in this appeal is the percentage of functional disability suffered by the claimant because of the injuries in the accident. Applying the method of assessment as extracted from the judgment of Rajkumar, it can be seen that the tribunal as well as the High Court both erred in arriving at the functional disability suffered by the injured claimant. The tribunal considered the functional disability to the whole body at 40%, contradicting doctor who deposed that claimant had suffered 40% permanent disability of right lower limb. The High Court further erred in arriving at a conclusion that the whole body disability of the injured to be at 48%, when the disability certificate specifically indicates that claimant had suffered 48% disability to his right lower limb. There was no justification to arrive at a conclusion that claimant had suffered either 40 or 48% functional disability based on right lower limb disability being 48%. Hence, we are of the view that both the courts have erred in determining the percentage of functional disability. So what Supreme Court is doing, my lord, is at paragraph 13. Having regard to the aforesaid analysis, we turn our attention to the facts on hand. The award of the tribunal would disclose that the claimant had sustained open grade 3 BL femur condyle with fracture ASOF, with fracture proximal fibula, with cili pest side and other multiple injuries. He was hospitalized for 14 days on account of injuries. Claimant is said to have sustained 48% permanent disability to the right lower limb as deposed by the doctor who issued the certificate. The said disability certificate remained unchallenged as rightly noted by the High Court. Thus, the assessment of compensation under the head of loss of earning capacity would depend upon the affected impact of such disability on the earning capacity of the claimant. In the instant case, tribunal as well as High Court has arrived at a conclusion that there is a permanent functional disability. However, it is not forthcoming from the award of the tribunal or the impugned judgment as to the corresponding functional disability. There may be case of whether the disability is permanent or temporary also. If the disability percentage is expressed with reference to any specific limb, then effect of such disablement of the limb on the functioning of entire body, that is the permanent disability suffered by the person, will have to be assessed or reconsidered for the purpose of computation of compensation towards loss of future income. In the instant case, the tribunal has not ascertained the impact of the earning capacity of the claimant in future by virtue of the disability sustained. However, it has proceeded to hold that there is 40% disability in relation to the right lower limb and has held that a sum of rupees 2 lakh is to be awarded towards disfigurement, hardship, inconvenience caused due to such disability. The High Court, in relation to the same, has assessed the loss of future earning capacity by considering the functional disability to the whole body at 48%, which has been held herein above as erroneous. Now, my lord, this is the point. This is the point, my lord, I'm relying upon. Thus, this court will have to undertake the exercise of assessing the whole body disability. And as per Almanaco manual, the whole body disability, when compared to a particular limb, disability would be 1/4 in respect of that of the lower limb. In the instant case, the lower limb disability assessed by doctor is 48% and 1/4 of the same would be 12%. And accordingly, the compensation is being determined by considering the income of the claimant at rupees 18,972. The compensation thus becomes payable for the loss of future earning would be 18,972 per month into 12 into 17 into 12% loss of earning capacity. This is 464, and thereafter, my lord, the other non-PQD were granted 9 lakh. So from 31 lakhs by the High Court, Supreme Court brought it down to 9 lakhs. My lord, the same principle I was pleading before your lordship. My lord, I was humbly requesting your lordship to consider in the instant case as well that, my lord, when my lord, the damage or the, my lord, injury is confined to the one leg or the lower limb, which is as per the evidence of the doctor and as per the medical certificate, my lord, the loss of earning capacity should be brought down to 1/4 from 85%. It should be around 20 or 21 or as I said, my lord, maximum, my lord, 25%. That also when it is 100%. So, my lord, it would be around 20 to 22% or 23%. Maximum should be the loss of earning capacity in the instant.
So, if I proceed on this 85%,
yes, and then bring it down by 1/4 because it is confined to one lower limb.
85%,
1/4 of 85%. This is what Supreme Court has said. Identical case, the clothing business, this gentleman also had. Tribunal granted 4 lakh. High Court made it 30 lakhs. Supreme Court said that no, the loss of earning capacity would be, you have calculated wrongly. You have done it of the whole body. It should be confined to 1/4 of the, since it is only confined to the limb, it should be 1/4. So this is how it was.
This is after Rajkumar's case.
Yes, Rajkumar has been considered here.
Okay.
I read that paragraph. My lord, paragraph 11 and future prospect was not granted.
Okay.
Your lordship said read that paragraph 11. The same principle was, my lord, followed by, my lord, Honorable Justice Ananya Bandyopadhyay. As, my lord, I was stating before your lordship. My lord, this is the last one. I will not trouble your lordship further.
Page 39.
It is there in the written notes, probably.
Page 39. Your lordship will kindly, my lord, kindly come to, my lord, to page 39. I'll just indicate.
39.
I'll just indicate, my lord, the paragraphs. Paragraph 4, my lord. United versus Amol Kumar Bhuiya, paragraph 4.
Yes.
Learned advocate representing the appellant insurance company submitted to have filed the instant appeal. Considering the deposition and exhibit indicating permanent disability to the extent of 70% suffered by the victim. It is further emphasized that victim had incurred a fracture injury restricted to right lower limb and not the entire body. So the tribunal should not have considered this. My lord, and then thereafter, your lordship will kindly come to paragraph 10.
Paragraph 10.
Lordship, internal page 6, my lord.
Internal page
6, paragraph 10 of this judgment of her ladyship.
Yes.
My lord, paragraph 10 says, my lord, the victim adduced evidence before the tribunal. During cross-examination, victim said, my business is still running. My lord, in the middle, at the relevant time of accident, my monthly sale was about rupees 10 to 12 lakhs. At present, sale amount is about 2 to 3 lakh per month. My said business is still running through my agent. At present, the price of the mobile set has reduced. So, my lord, business is running. Although the, my lord, the quantity or the, my lord, sale has reduced. That is there. Business is running. That is the issue. And then paragraph 12 and 13 is the outcome.
Yes.
Paragraph 12, learned advocate representing the claimant stated certain liabilities toward payment of remuneration, so and so. My lord, in the middle, the, my lord, UP State Transport Corporation, my lord, this what I had cited of the Supreme Court is referred to in the bold letters. And then, my lord, this after that citation, this judgment, that citation, my lord, the bold letters, immediately thereafter, had explained the extent of disability to be the computed, whether the particular part of the body sustained injuries inconsistent of the entire body of the victim. In the instant case, victim suffered 70% permanent disability of the right lower limb, as mentioned in certificate by MR Bangur Hospital. Then paragraph 13, in view of the aforesaid judgment, my lord, this is the clinching point. Paragraph 13, the disability will be reduced to 1/4 of 70%, amounting to 17.5%. This is what was held by her ladyship. And then, my lord, on the basis of this 17.5%, your lordship
So
will kindly
future prospect was awarded.
My lord, in this case, my lord, future prospect was also not awarded, following the Supreme Court, because business is running.
Okay.
So they are getting advantage of future prospect also. And 85%, my lord, the 50% loss.
How much future prospect is
my lord,
considered?
40% granted here in this
Future
case.
prospect.
Yes. My lord, this everything cannot be, my lord, clubbed together.
Anyway,
this,
you
my lord,
continue
this
with
is,
the after recess.
yes,
After
yes.
recess, my lord.
Grateful to your lordship.
My
I
lord,
con-
it will continue after.
Yes, yes, yes.
My lord, may I take your lordship's copy? That is my copy. It is for your
Oh,
lordship's copy.
Lordship, the mark করে দিয়েছেন?
Have your lordships have marked it? I shall not.
Anyway, you give that.
My lord, if my lord has marked, my lord.
No, I have not marked.
আচ্ছা, ঠিক আছে.
Then it's your lordship's copy. I shall.
Yes.
Grateful to your lordship, my lord.
Yes. Hence, this appeal FMA 357 of 2024 stands disposed. Judgment and award dated 23rd February 2017, passed by learned Judge Bench 2, City Civil Court, Calcutta, in MSC case number 675 of 2009, stands affirmed so far principal compensation is concerned. However, interest awarded is reduced to 6% per annum. The appellant Bajaj Allianz General Insurance Company Limited shall deposit the compensation awarded by learned trial court along with interest at the rate of 6% per annum from date of filing claim case till today before Registrar General High Court Calcutta, if not deposited. Such deposit shall be made within 8 weeks from the date of communication of this order. The respondents' claimants will be entitled to withdraw the compensation upon compliance of necessary formalities. Balance amount, if any, with accrued interest will be returned to the appellant insurance company.
Grateful to your lordship.
Yes, Mr. Bhattacharya.
But item
is pending for a long period.
Yes, but
I have heard it there and have continued.
difficulty is, my lord, just today, my lord, I have been, my lord, requested to represent the state, my lord. I've just received my memo of appointment, my lord. So, my lord, I find, my lord, it's a question pertaining to law, my lord, interpretation of the legal provisions as to whether the GTA, that is the Gorkhaland Territorial Administration, whether they at all had any competence to conduct the teacher's eligibility test entrance examination. So that is the moot point, my lord. The state.
With regard to that, the state filed an affidavit.
My lord, I will be requesting my learned friends, my lord, to supply me with a copy of the pleadings, my lord, since it's a matter pertaining.
Millard, the state has not filed any affidavit. The GTA has filed an affidavit wherein, Millard, all the communications exchanged in between the state and the GTA has been annexed. And Millard, it was argued this.
My lord,
copy of the affidavit of GTA filed by GTA is with you.
I will, my lord, just request my learned friends can supply a copy.
And Millard, if Millard kindly recalls, when your lordship heard this matter and made it CAV in the circuit bench, at that point of time, your lordship has also heard the state here. And from the communications which were annexed in the affidavit of the GTA, Millard, today, Millard, there could not be any hesitation, Millard, for your lordship to hold that the GTA was competent to hold the examination.
You see, both GTA and state were represented before.
But I find from the order, my lord, I just searched from the server, state did not appear, my lord. Last few occasions, the state was
not here, but in Jalpaiguri, state was represented.
State was represented, Mr. Bhattacharya.
Jalpaiguri. Thereafter, it was made part-heard. Not part-heard. The judgment.
Not part-heard, it was made CAV.
Yes, judgment was reserved. Then thereafter, a recalling application came from side of the petitioner that let it be heard once again.
Kindly hears us out, my lord. Now, my lord, let us, my lord, indicate the stand. My lord, I am told, my lord, that the state was represented in 1519 of 2025, but in so far as 893 of 24 is concerned, the state was not represented, my lord. That is what I am told.
The prayers are absolutely identical in both the petitions.
Yeah, the points
my learned senior friend will also consider this, Millard, that the prayers are identical. The stand of the state cannot be different in these two petitions.
Very well, the stand of the state may not be different, but the stand of the state needs to be indicated and argued. So, my lord, I was just humbly beseeching, my lord.
Submitting on behalf of GTA.
No, for the state, my lord.
For the state?
Yes, for the GTA, I understand Mr. Mojumdar is appearing. My lord, my contemporary in office, Mr. Rajdeep Mojumdar, my lord, he will be representing the GTA. So,
no, Millard, with leave of Mr. Bhattacharya, Millard, last occasion there was a submission made before your lordship that Mr. Mojumdar will further not appear for GTA any further. In view of his appointment as the learned AAG for the state, he won't appear. That was the submission made. And on the basis of that submission, your lordship granted the adjournment.
the petitioner has a right to argue on his case. He is the dominus litis. But the petitioner cannot have a say as regards who will be representing which authority, my lord. This, my lord, I'm taking serious exception, my lord. I'm taking
No, Mr. Bhattacharya, what I am saying is, on the last occasion, the adjournment was sought on this ground that Mr. Majumdar will not further represent the GTA.
This is not the way we argue before the honorable court. We are before the highest court of law in the state. Let me finish there.
And this is the way adjournments are sought.
You are most welcome to advance your submissions. Just let me
No,
complete.
this has repeatedly been adjourned. Kindly see how many times adjournment has been sought. I am aggrieved by these repeated adjournments taken on grounds which are as good as this.
This is not the way.
No, I am saying your lordship is privy to this. Your lordship is aware on what ground the adjournment was sought on the last occasion.
Just a minute. Let your learned senior friend Mr. Bhattacharya appear on behalf of the state. If Mr. Majumdar is unable to appear on the next occasion, you take written notes of arguments and submit on the next day. Whatever it is. If Mr. Majumdar appears, well and good. Otherwise, you bring your written notes of arguments.
It's a short point.
Yes.
We can do that.
So let it be concluded on the next day.
Yes, but grants me some time, my lord, at least, so that, my lord, I can also, my lord, make my submissions upon receiving, my lord, proper written instructions from the state.
Record and order. Learned advocates for the parties at present. Mr. Bhattacharya, learned senior counsel appearing on behalf.
No,
Mr. Bhattacharya, learned.
Mr.
Bhattacharya, learned senior counsel AAG appearing on behalf of State of West Bengal, prays for some time to submit on the next date. The learned counsel for the learned junior of Mr. Majumdar representing GTA is present and praise time on behalf of Mr. Majumdar. The matter stands adjourned till 4/8.
Some more time, my lord. 4/8 is too less. Yes, we need to get back with the instructions also, my lord. I understand.
I won't object to that, but my lord, kindly sees how many times it has been adjourned. That's all, my lord.
No, Mr. Bhattacharya is appearing for the first time. Okay.
No, that's all right. That's all right. He is appearing for the first time.
No display. Is it Mr.
Ghosh? He is appearing for the first time. He is singing.
No, I am. Yes, that's right. He's appearing for the first time, my lord.
Hey, Bikram, আমি রে এরকম করিস না
withdrawing his allegation.
No, it was not an allegation, my lord. The only confusion arose because on the last occasion, Mr. Majumdar said he will not represent GTA. That's what I was indicating. Nothing else, my lord. There's no personal nothing against Mr. Bhattacharya.
How much time do you require?
But grants me at least 3 weeks time so that I can come back. I can finish it off, my lord.
2 weeks, my lord. 2 weeks. Mr. Bhattacharya's submission also accepted. My, my lord,
8, 2026 for submission on behalf of State of West Bengal
and the GTA, definitely.
And on behalf of GTA, it is hereby made clear that in the event Mr. Majumdar is unable to attend, the junior counsel who is appearing must represent the GTA.
But I understand the
written notes of argument.
I understand the stand of the state as well as the GTA will be ad idem, my lord. Because the state contest, I also once had the opportunity to appear, maybe 2.5 years back, in this matter once or twice, So the stand is not, at variance.
You see, again the petitioner has to reply after you submit. Writ petitioner has to reply thereafter. Anyway, after all, only on the
question as much as I can, call out, in this short time. It's a question pertaining to the competence of the GTA to have the test, It's a it strikes at the root.
Yes, right.
It is found that they were not competent. The prayers as made by the writ petitioner, that automatically will wither away, So, it will come back on the 17th.
I will hear you as well as I will grant all of you opportunity to file your written notes of argument.
So 17th, will come back with the submissions,
yes, 17/8/2026 at 2 p.m.
2 p.m. Grateful. Extremely grateful. With your lordship's leave.
Yes, thank you.
My lord, may kindly direct, my lord, the GTA to supply all the meetings to me, my lord, since they will be having everything.
Learned advocates for the appearing for GTA is requested to serve copies of the petition and affidavits upon Mr. Bhattacharya, senior counsel.
I'm appearing with Mr. Chatterjee. With Mr. Loknath Chatterjee.
Okay. Advocate on record appearing for state of.
আমাকে দিয়ে দিবি তাকে, আমাকে বা লোকনাথকে দিয়ে দিবি তাকে। Grateful, my lord, in both the matters, my lord.
Okay.
Extremely
Yes, yes, both the matters.
Thank you. Thank you.
Yes. Yes, Mr. Singh has concluded.
My lord, let Malad finish talk, my lord. My lord, as regard, my lord, there are mostly three allegations, my lord. One is there is no evidence from the side of the claimant that the business was closed. Second was the second was the there was no loss of income. And thirdly, my lord, the extent of disability he suffered was since it allegedly it confines only to the lower limb, then the functional disability should not be even 50%, it should be less. These are the three points which had been raised by the Mr. Singh today, as well as I remember it on the last occasion also, my lord. My lord, I should first come to page 8 of the affidavit of chief at paragraph 9, my lord. Before the time of accident, I used to earn rupees 28,900 per month from his garment business, namely SS Enterprise. So, my lord, it is explicitly stated that before the time of accident. And then, my lord, has my lord got it?
Yes.
Before the time, page 9, paragraph 9. Thereafter, my lord, page 10, also another 1, 2, 3, 4 lines from the bottom, there was 12 employees in my garments. So there was 12 employees. It is on the cross examination. It is more serious, because this time the contesting appellant has the opportunity to cross-examine my witness, not only witness, the victim and the claimant himself. So there was, in their cross-examination, it came out there was 12 employees in my garment business. So it was, the language is to be kind. It was. It is not is or has been. It was. I have submitted IT return before the authority concerned. Then again, I have filed documents that I am totally disabled now. Totally disabled now. This is the evidence came up in the cross-examination, not even in not only in the affidavit in chief, in cross-examination, and there is no contradictory evidence to show that with that kind of disability, my client can conduct his business and run his business.
Okay, what have you stated in your chief regarding employees? Have you stated anything?
No, my lord, it has not been
regarding your business. Any particulars?
No particulars. That was only thing that before the time of accident, I used to earn rupees 28,900 per month from my garment business. It would have been namely SS Enterprise as a proprietorship business. This is all what is there in the evidence, my lord. But it has been made better in cross-examination. He has faced the cross-examination. In cross-examination, he has stated that there was 12 employees. So that the interpretation means that there was 12 employees, not that there is 12 employees. And I have filed documents that I am totally disabled now. The document which is referred here is the disablement certificate. It is could not be referred because that has not been proved when this PW was being produced. That is that they say that I have filed. That has not been gone into evidence on that date. It was gone under evidence on the subsequent date.
After the doctor was examined.
After the doctor has been. That is why it is stated that it is I have filed document to show. Now, my lord, the crux of the matter is the income tax return, my lord. My lord, kindly come to, it will be convenient for your lordship as well, my learned senior friend, come to page 8 of my written notes of argument, my lord.
Yes.
Now, my lord, here one thing needs to be the air needs to be cleared, or in one respect, my lord. It is for at the cost of repetition, I am just drawing your lordship's attention or reminding your lordship that the assessment year is the previous year and the financial is the previous year and the assessment year follows on the next year.
When the assessment is made.
When the assessment is made. So, my lord, what has been the gross income which was in 2015 to 16, it was for the corresponding financial year 2014 to 15. So it was 31st April 2014 to 1st April 2014 to 31st March 2015. Next, and the accident happened, my lord, on 26th June 2015. So the income tax return which was filed for the assessment year 2015 to 16, it happens to 1st April 2015 to 31st March 2016 at page 9.
Page 9. Yes.
So now, and the accident happened on 26th June 2015. So it was the 3 months income. So it comes to nearly, if we figure it out, it is 90,000.
2015
yes,
to 31st March 2016, you have submitted your return.
Return. And it is the relevant year.
From 1st March to, that is 1st April 2015 to 31st March 2016, you have submitted your return. And the accident took place on June 2015.
2015. So this is the return for the 3 months income.
Okay, 1st April to 31st March. No, you have stated 1st April to 31st March 2016.
16.
That means entire, even during the accident period also, you have submitted return.
So that is for it is the income is for 3 months because in the accident happened in 26th June. So last or at the fag end of the June.
Right. Your accident took place, that is the accident took place in the month of June. The financial year is April to March. Okay. But April to March was the financial year. The accident took place in the month of June. So you have submitted the return in the month of April or May in 2016.
Month of April 2016. In 16.
Yes.
After 31st March 2016, it has been submitted.
Yes. 2016-17 is the assessment year. Yes.
So that is being pointed out as my income. So that was the income for only 3 months. Only for the
After
12.
Earn anything?
I could not earn anything because
you may be hospitalized, but the employees were there.
Employees were not there. My business
entire business was stopped.
Entire business was stopped. That is why
for 9 months.
For 9 months, and it has been closed for all, my lord. For all. It is my case.
Okay. Have you stated that in your chief that the business is closed? In your chief? that thereafter my business is closed?
In chief, it is not.
Yes,
It is
yes.
only, it is
Okay.
it
That
is
thereafter I am not working, my entire business is closed.
it is the exact wording is not there, my lord.
Then
Exact wording is not there, but before the time of accident, it is only, it is in impliedly it is so, but it is
question is,
exact
you see,
wording is not there.
when you are, how can it be 3 months? You see, the business cannot be closed for the accident of one proprietor. There are other employees, managers who are running the business. And you have nowhere stated that after the accident, your business is closed. Nothing, you have not stated in your chief.
No, manager was not there, my lord. It is proprietorship.
Yeah, you see, if you have 12 employees, there were employees who is to look after the business. How is that? When 12 employees are there, none of the employees are there to look after your business.
No, my lord, it is the case, but it has
You have nowhere stated that your business was closed after the accident. After your disability, your business is closed. Nowhere in your chief.
Before the accident, I used to earn at the.
Yes.
No, in chief, it is the exact wording was not there, my lord.
So it is not a case that after the business, after the accident, you have lost your business. And what is the income tax authorities? PW2 say?
PW2 now, it is
PW11.
My lord, it is PW11 at page 21, my lord.
Yes, what is the deposition of PW11?
PW11 is that, my lord, kindly come to page 21. And the net income showing
that is
2014 assessment year 2014-15.
2016-17. That is previous year 15-16.
15-16.
89,123. Yes, there is no statement on your side that your business is closed.
There is no, but my lord, there is certificate of enlistment, my lord. It also shows that after 2014 it has not been renewed.
Question is that you must plead that you don't do any business. Then only the other side can, you see, contest on that. You have nowhere stated that after the accident you are not doing business or you are unable to do business.
My lord, then also if that be so, my lord, even the
your case may be that you are not earning like the previous year. It may be loss of earning capacity.
But even that be so, my lord, then 2015 to 16, my lord, the only 90,000 for the 12 months, my lord. If my business is, I could not earn, my lord. It's that is why the income is so less. Because it is in today's world, it cannot in any way, when the business which was running at the, if my lord kindly take it, the tax return of the previous years, it was for 2000 financial 11-12, it was 2,41,000 and odd. 12 to 13, it was 2,80,000 and odd. Then it is 2,46,000 and odd. Thereafter 3,64,000 and odd. And then it comes to 89,000. My lord, it cannot be so that once it is shown in the income tax. So in today's world, my lord, these things cannot be possible, my lord, because everything today is online, my lord. So it cannot be so that I am running it in other way, but I am not showing it to the income tax.
There is no case from your
Since
side
it is a
that
proprietorship.
after the accident your business is closed. It is not your case before the trial court. Only there is a loss of income. Yes. What decisions you are relying?
My lord. My lord, one. My lord, a few seconds. না না এগুলো কোথায় কোথায় বন্ধ হয়েছে কোথায় করেছে বন্ধ হয়ে গেছে কোথায় করেছে যে স্টোরটা বন্ধ হয়ে গেছে বিজনেস বন্ধ
এই নাম্বার 3 তে সিসি লিখেছে ওটা আমি যশাদকে বলিনি মহিলার উপরে ক্লেম করছি
আমি তো দেখি না ততক্ষণ টাইম যাচাই করে গেছে
সোল পেমেন্ট এটা আছে সি এটা কার করছো তুমি এখানে আবার সি
ও আচ্ছা আচ্ছা ঠিক আছে
এটা বলছি না কিন্তু
আচ্ছা ঠিক আছে
পুরো ফিটিং টাইপ ভুল আছে
দেন my lord my lord then my lord may I
তুমি অনেক দিন থেকে কনফারেন্স করতে
Yes.
my lord my lord as regards my lord my lord then I come to the extent of disability my lord extent of disability is at page 77 extent of disability my lord at column 3 the though it is not it is column 3 85,000 having chance of having changes of
Page
variation and
77.
page 77
Which case? Decision? Which decision?
my lord the way the paper book my lord only
Page 77.
77 of the paper book my lord
It is up to 66.
no paper book
Oh, paper.
the extent of disability
disability certificate my lord is referring to.
Yes.
my lord the his percentage of disablement is as calculated as 85,000 85% and having changes or variation the case requires review after blank years so my lord had it been a case of temporary disablement there would have been an indication as to the number of years after which it needs to be and my lord at paragraph para 7 my lord column 7 escort allowed so my lord one thing my lord at the outset may I submit that it is not the case of whether amputation has been done or not if a limb is being paralyzed or a limb is being becomes dysfunctional the gravity of the disablement and the difficulty of the victim is to be assessed my lord and that is the best can be assessed the extent of pain suffering and the difficulty in working for the future using the limb for the future or his entire life needs to be assessed my lord it is not that only if amputation is done this will be that disablement and only then my lord the may I ask may I say to myself that only then this medical the concept of medical board would have not been done my lord because amputation can even my lord since the assessment is done by the honorable judges and also from this side of the or from the bar my lord all are educated so we can also assess that if it is amputation from this portion and this will be it is not that it is a dynamic science my lord so that dynamicity needs to be assessed by an expert and that has been it is by a medical board it has been assessed to be 85,000 because only thing that is because it is not there is not amputation is an reflection of is a reflection interpretation is an reflection interpretation my lord I am not pointing to anyone I am not personally attacking anyone in this interpretation is a product of a closed mind my lord it needs to be assessed as an open mind and once this certificate has been produced this evidence cross examination has been produced then my lord without any contradictory evidence the difficulty of the extent of disability cannot be diluted my lord this is my humble submission and my lord on this point name may I now only and with this kind of disability and the nature of business since there is evidence I can what I submit before your lordship I cannot now improve my case what is in the evidence it is there but my lord but at the same time my lord I cannot I shall be doing injustice to my client if I do not point it out to your lordship the difficulty of my faced by my client and the what evidence is already on record which came up in the cross examination And there has not been any evidence to the contradictory evidence also that this business has been run. So, my lord, we need to visualize at this juncture with this kind of difficulty and with the income for only which appears to be for only 3 months, whether the claimant has stated the business can be run by it would have been possible to run the business or not. So it needs to be assessed, and I consider it my duty to place it before lordship. Then, my lord, it is entirely before your lordship, and I bow down to it. And my lord, in this case, my lord, thereafter I shall not take to the page 20 of my written notes of argument. No more pleadings, my lord. Only the judgments, my lord. The paragraph 10, the aforesaid judgments are instructive in nature, my lord, from the bottom, my lord. The aforesaid judgments are instructive for assessing the compensation payable to the appellant in the present case. As consequence of the accident, the appellant has been incapacitated for life since he can walk only with help of a walking stick. He has lost his ability to work as a driver, as he would be disqualified from even getting a driving license. The prospect of securing any other manual labor job is not possible, since he would require the assistance of a person to ensure his mobility and manage his discomfort. As a consequence of functional disability suffered by the appellant must be assessed at 100%. Page 20, my lord. And my lord, this judgment has been passed, taken care of, Ajay Kumar Rajkumar, which is being popularly cited from the insurance side, my lord, and sometimes taken as an yardstick to prove the understatement of the claimant, my lord. To claim that all claims are to be understated, my lord. So this judgment has taken care, my lord, of Ajay Kumar Rajkumar at page 19, my lord. I am not elaborating, if your lordship. Here, my case, even if I take it to Ajay Kumar Rajkumar, where it has been stated that it has to be assessed whether he can do any work or not, it is my case that with this kind of disability, with this kind of difficulties, he cannot do any work. So he cannot run his business. Then, my lord, I would take your lordship to the judgment where page 30, that UP Road Transport Corporation 34 to 36, my lord.
Yes.
With regard to what I having regard to the aforesaid analysis, we turn to our attention to the fact on hand that tribunal would disclose that the claimant has sustained open such and such injuries, fibula, other medical. He was hospitalized for 14 days. Claimant is said to have stated sustained 48% disability. The disability to the limb as deposed by Dr. PW3 was issued the said certificate. It was the doctor PW3. The said disability certificate remained unchallenged, as rightly noted by the High Court. Thus, the assessment compensation under the head of loss of income would depend upon the affected impact of such disability on the earning capacity of the claimant. In the instant case, the tribunal as well as the High Court has arrived at a conclusion that there was a permanent disability. However, it is not forthcoming from the award of the tribunal or the impugned judgment as to corresponding functional disability. There may be case of whether disability of a permanent whether the disability is permanent or temporary. There was a confusion whether it is permanent or temporary, but it is here it is distinguished on this to this extent that it is temporary. In my case, in if the disablement percentage is expressed with reference only to a specific limb, even effect of disablement of the limb on the functioning of the entire body, that is the permanent disability suffered by the person, will have to be assessed or reconsidered for the purpose of computation of compensation towards loss of future income. In the instant case, tribunal has not assessed the earning capacity of the claimant by virtue of the disability sustained. However, it has proceeded to hold 40% disability in relation to the right lower limb and held that a sum of rupees 2 lakhs to be awarded towards disfiguration. The High Court, in relation to the same, assessed the loss of future income body to 48% and held to hearing report as erroneous. Thus, the court will have to undertake the exercise of computed particular limb disability as 1/4 of the lower limb. In the case of Dr. PW3, 48%, 1/4 claimant. Thus, the compensation becomes payable to future, and the compensation under the head of a special diet. These has been sustained. My lord, here the case what remained, my lord. Here there was the High Court arriving. It was there was a distinct fact that the claimant was working at that time. My lord, one with regarding page 32. My lord, kindly come to page 32. The considering the material available on record, important question arises before this court as to what would be the income to be disposed, the loss of income. It is to be noted that the tribunal and the High Court given divergent opinion in this aspect. While the tribunal considered the income of the claimant to be 45,400 on the ground that claimant proved working in the RK enterprise, the High Court also accepted the claimant as adult, but also held that he had income of his own business as well. Therefore, his income to be determined considering income tax returns filed by the injured claimant. On perusal of the award of the tribunal, it is clear that the claimant, while filing the petition, contended that he runs his own business and did not plead that he works at RK enterprise. It is trite law that no evidence can be laid beyond pleading. In the case at hand, the tribunal erred by allowing the claimant to lay evidence on the point that he was working as RK enterprise, which was not pleaded in the claim petition. The tribunal also erred by allowing PW2 to depose that the fact was working as a RK enterprise. Be that as it may, we are of the opinion, on the basis of the evidence available on record, that is income tax return, it can be inferred that the claimant's main income of source of income was MS Fashion Fabric, a company run by him as pleaded in the claim petition. It is settled proposition of law that income tax returns of the claimant are credible source of evidence. Therefore, the average of ITRs filed by the claimant to be considered for determining monthly income of the claimant. So, average income tax return filed by the claimant would be 2,20,006 and odd annually per month. So, my lord, if that judgment, which has been relied by my learned friend, my learned senior friend, is to, may be relied, my lord, then the entire judgment needs to be relied. And from that it comes that the income tax return has to be taken into consideration. And in this case, this is the case cited by my learned friend, my learned senior friend. I stand corrected with unconditional apology.
So it is well settled that, you see, when you are having a business, it's not that the business will stop because so many employees are there. So that is what the observation of the Supreme Court. Claimants runs a textile business.
Claimants runs this textile business. So it was running. So income tax and income tax.
Claimant was having source of income, you would not lose the same. So you will not lose the income. This is the observation.
Here, my lord, yes, my lord. Here, what happened, my lord? The claimant claimed that I am earning from business. Claimant, but what claimant, where it is, what claimant in malified way, what he did, he wanted to bring it a further fact that I was employed there, I lost that income. But here, claimant admitted that from the business was running. And this business and the income tax return, here also from that income tax return, it came before return. So here the claimant, there was a malafide on the part of the claimant. Here only difficulty is faced by my client, which I cannot improve, my lord. I am candidly accepting that there is the specific evidence is not there, specific wording is not there.
It's quite natural.
At that juncture,
This whole big business will not come to a halt for your suffering injury.
So, but from my lord, but
It's
this
not
is
a professional or experts or something like that. So many employees are there, they will run the business.
There was, my lord, the specific words that there was, not there is.
So during your injury, so entire establishment will be closed.
It
just
is my
just because you have suffered an injury.
It's not only injury. I am totally disabled. I cannot move, my lord.
Maybe, but it's not an amputation case. You see, disability is there. But you see, even if you go once a week in a business or once or twice in a week, there is no bar. It's not that you are discharging service, that you have to attend office every day. There are so many managers, employees who will run your business. Yes, it may be that some employees have reduced, some income has reduced, that can be. But no, it's not your case that your business is closed. And even if you say that, it will be very difficult to believe that an establishment will be closed for becoming a person becoming a disabled.
কনফারেন্স কর আমার থেকে কনফারেন্স করছিস আমাকে পাঁচ দিয়ে
দাঁড়া, খেয়ে গেছি, দাঁড়ান। আরে খেয়ে গেছি, দাঁড়ান না একটুখানি। না, এই তো একসাই তো মামলা করছে,
তুই ঘাট ধরে টেনে নিয়ে এলি।
হ্যাঁ, তো মরতে গেছি, তাতে একটু মরছে, একটু আনন্দ।
Yes, anything?
And my lord, the same thing as
So you have relied upon the decisions, as well as you have prayed for enhancement also.
Because my case is that
100% disability, and you have prayed for enhancement of the compensation.
Enhancement of the compensation, my lord. And my lord, one thing, my lord, I at the with all humility, I am submitting before your lordship, my lord, the interpretation of statute and pleading, my lord, it has to be literally so if it is
so to fulfill the object of the act,
to fulfill the object, so my lord, if it is literal interpretation, then there was 12 employees, my lord. It is not there is 12 employees. If the court disbelieves it, I am with folded hands. I am out
it
to
is
bow.
not your case that your business establishment is closed. First of all, then only you can.
There was, my lord, there was before the time of accident. I used to earn, my lord, before the accident. So that is the evidence, my lord. At page 8.
Not a case that after accident you are earning is zero. You are sitting at home doing nothing. All employees have gone home. Anyway, I shall consider the decisions relied upon by you.
And my lord, the judgment, my lord, the last decision is on the may not be relied because my learned friend, my learned senior friend has not pleaded on it. It is on the contributory negligence from the last decision may not be considered. Only the judgment passed by the by her ladyship Ananya Bandyopadhyay, relying on UP State Transport is also on the same point, my lord. The functional disability has been relied. This is my all my
future prospect you have submitted that 30% future prospect is there.
Yes, my lord. Not one line rejoined there, my lord.
No, Supreme Court has said that future prospect
Not to be given. Not to be given. In our case, it has been given. My lord, I dispute that also.
40%.
Yes, 40%. My lord, not even one answer was given to your lordship's query. He says that I was earning 29,000. What are you earning now? Very, my lord, very, very deliberately that has been suppressed, not told to the court that at presently you are earning maybe 50,000. You did not say that. It's asking, my lord, the honorable court to assume things. He says there were 12 persons. What about today? Why not 25% today? Why not I assume 25%? He said, no, don't assume that. Assume that today it is 0. And your lordship, the page 77 most clinching argument, my lord, of mine is this injury is confined to the left lower limb. That is what the disablement certificate speaks about. So the moment it is confined to left lower limb, my lord, the functional disability has to be, my lord, 1/4. In view of, my lord, this UP State Transport
Anyway, I shall
Corporation.
consider the judicial decisions.
Lordship, my lord, that is what, my lord, the Supreme Court says. And, my lord, taking note of that, my lord, your lordship will kindly, my lord, assess the, my lord, the assessment, my lord, the computation afresh, and, my lord, at least not more than 20% of the loss of earning capacity is to be assessed. And, my lord, this 89,000, what my London friend is speaking, my lord, the claim case was filed in January 16. And, my lord, this subsequently to that, my lord, I again say deliberately those income tax returns have not been annexed or have not been produced before the Honorable Court. The dates would be there. Much after that, my lord, much after filing of the claim case, this assessment or this return has been filed. So, no, if impliedly, my lord, it is, my lord, an afterthought to reduce the income, to show it to the court. Had it been prior to the filing of the claim case, I would appreciate it, but I wouldn't have said anything. This return was filed after the filing of the claim case.
Yes, record an order.
I'm grateful to your lordship.
Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 10/8/2026.
10th of August, my lord. Grateful to your lordship.
And well, there is a very small correction. It is noted in the notes of argument, Sheikh Qasim to Qasim, my lord. If, my lord, it can be incorporated, my lord.
Or correction, have you filed any application for that?
Application has been filed, my lord. They need not go through the application, my lord.
Application for correction.
Application of correction has been pending, my lord. At the last portion of my, before parting, I must pray.
The application, the file by the claimants respondents to rectify the name of the claimant Sheikh Qasem Ali.
Sheikh Qasim to Sheikh Qasem Ali.
Sheikh Qasem Ali stands allowed. Let the name of Sheikh Qasem Ali be corrected as.
No, Sheikh Qasem be corrected as Sheikh.
Oh, Sheikh Qasem be corrected as
Sheikh Qasem Ali. K-A-S-H-E-M-A-L-I.
Sheikh K-A-S-H-E-M-A-L-I.
My lord, the cost title is K-A-S-E-M. H would be added. K-A-S-H-E-M.
Yeah.
Ali to থাকবে দুটোতেই আছে.
Yes. Yes, the যাকে ওটা অর্ডারে থাকলো আর কি এফেক্ট দেবে
এটা এটা কোনটা এটা আমার
একই রক্তের দুই
না না ওটা তো আমার নামই আছে
নামে আছে এখানে অনেক
item 8
my lord I am for the appellant in this case
Yes.
My lord, this is a case under section 166 MB Act.
Yes.
Claiming compensation of rupees 3 lakhs.
Yes.
Now, my lord, kindly.
How much is awarded?
Awarded 1,10,545.
Yes.
Here the medical bill was 15,000.
Injury case.
57,000.
Injury
case. 57,545 is the medical bill.
Yes.
So there is no dispute about that. Dispute is number one, huge assessment of disability, permanent disability to the extent of 50%. Assessed by Dr. P.K. Mondal, who did not treat the patient, but he was the head of the Department of Orthopedic Surgery, National Medical Hospital. So he was in the medical board. Not in this case, but in different cases. Now, my lord, in this case, income was assessed only 15,000 per year. It is too low. 15,000 per year. Multiplier also disability 50%. 5.5 months was remained in the hospital. Injury is so grievous.
No, medical expenses, how much it is taken?
Medical expenses 57,545. That was awarded.
Okay. And what else? That
penance suffering only 5,000. Only 5,000. It is also meager amount.
And the percentage of disability?
Disability 20% he assessed. But without any assigning any reason.
That is 48,000.
It is 48,000, yes. Multiplier will be 18, my lord. It will be 16 here. But it will be 18 as per decision of the Supreme Court. Prononcity. My lord, 15 to 20, 19 years old. So it will be, my lord, 18. 15 to 25, 18. 24, 18. Sorry, 15 to 24, 18, my lord. So multiplier will be 18, my lord, according to Supreme Court decision. What is the nature of injury, my lord? Kindly see it. Page. Remained in the hospital 5.5 months, my lord. Thereafter treated another 2 years. Thereafter outdoor patient for the last 2 years. Up to 2007. This is also very vital. Period of
7,545, both present and future expenses, medical expenses.
Medical expense actually present, because not future, only present, because it was proved. It was proved in the evidence, exhibited documents.
And if the multiplier is 18, how much it comes?
Oh, it will be. So, sir, my lord, at the same time, what will be the quantum?
54,000 probably.
It
will come to 54,000.
50,000. Nah, 15,000. It will never be 15,000, my lord.
No, 54,000.
No.
The incident of which year?
Incident of 5.
2000?
2005. 4,000 actually. Up to 4,000, 3,000.
So what was your occupation? You have stated
occupation actually. He was the
lawyer's clerk.
Actually, he was in the actually the law clerk. But tribunal disbelieved that he cannot be a law clerk.
So let us see the evidence.
Evidence, my lord, see. My lord, kindly see page.
Oh, did he give his license that he is a lawyer's clerk? So that is the vital proof. He may be an employee of a firm. Yes, what is his evidence?
Now, evidence of employer added evidence.
Oh, employer has given evidence?
Yes.
Let us see which page.
Yes. W, my lord. No, one. My lord, page. Page 40-41, my lord. 40-41. EW4, my lord. Muntamuddin Gazi. I am a stamp vendor of Alipur Judges Court. Oh, no lawyer, license, he was the license vendor. Arif Gaji used to work under, oh, license vendor, not the law clerk, license vendor, I'm sorry, madam. License vendor under, he worked. Arif Gaji used to work under me, he is present in court today. I used to pay 100 per day. And this certificate is written by me and my elder son Wasim Gaji and signed by me, marked exhibit. I know Arif Gaji suffered motor accident. After this accident, Arif Gaji is not in a position to work under me. This is his evidence of under whom he used to work. And this amount also very meager at that time.
That is 3,000.
My humble submission, it will be actually 3,000 per year, per month. And no future prospect were allowed. In this year, fittest case for allowed in future prospect. No future prospect was given. At the same time, penance happening only 5,000 or 5.5 months remained in the hospital. Thereafter, 2 years he attend the OPD hospital or in hospital treatment. All treatment purposes are in hospital. Finally, she paid.
So future prospect, if 25% is added, it comes to
25% is 40% will be.
Okay, 40%.
Yes.
6,000.
Actually, 40% it will be. Age between 15 to 40, 40%. হবে না হিসেবটা করতে 3 4 40% মানে 3 4 12 200 into 18 into percentage what my lord will assess.
Oh, it comes to 75,000. If future prospect is added,
40%, my lord.
Yes, 75,600.
Your lordship is computing on what basis?
No, 15,000.
My lord, 15,000.
Per annum.
1,000 is the per annum. You go by that.
Lordship.
Future prospect 40% added.
That is 6,000.
6,000. That is 21,000.
Lordship.
21,000 into 20% disability.
Lordship.
Multiplier of 80.
Disability assessed by the board and but
Very well.
Sir, बोलते दिन एकटू
We are going by the formula. So if future prospect is added, it comes to 75,600 instead of 48,000.
Lordship.
So this is the 75,600.
in the year 2005.
You see, if you say it is 2005, then we have to consider what are the decisions at that point of time.
But in 2005, the maximum was 15,000, number one. In 2005, there was no future prospect. Rather, up to 2015, there was no future prospect. This appeal of 2007, this appeal is kept waiting for 20 years. And after 20 years, he wants to take advantage of the judgment which were passed in the year 2020. Your Lordship will kindly say the conduct. Yes, Your Lordship will kindly say the conduct also.
My lord, disability 20% from 50%.
Disablement by a private doctor.
Same. No, that this person did not examine him. Okay, you see, only the board can say. Board can say.
My lord, kindly see the nature of injuries.
Very well. What was the difficulty to get it assessed by board? What was the difficulty? You see, if you don't go to board, okay. If you go to private doctors, you have to accept whatever the court thinks fit and proper.
Board did not assign any reason to accept the.
Very well.
20%.
You see, the one reason the doctor did not treat him, and this is not by board. This is sufficient.
My lord will kindly assign the reason, my lord. since it is the fault of the court that the court did not assign, your lordship will assign the reason. Supreme Court is regularly deprecating these medical opinions. Supreme Court is saying, Lord, above 40%, Lord, I have shown your lordship the disablement act. It cannot be granted. It has to be gone to the board. He did not go to the board because of maybe the professional advice given, Lord. I do not know. One chooses not to go to the court. One chooses not to get the matter, Lord, keep pending matter for 20 years and says, Lord, they give me the advantage of the, Lord, the recent judgments. And that too, Lord, had he come with the clean hands. Lord, initially he was shown to be the law clerk, then he was not to be law clerk. His income, Lord, 100 rupees a day. And Lord, the claimant himself says, which was not shown to your lordship, that I am getting 2,500 rupees per month. If it is 100 rupees a day, Milord, and he is working for a stamp vendor, Milord, how many days, Milord, the courts are open? If I put this question to myself, High Court is open for 210 or 212 days. Yeah. So maximum, Milord, 212 days without getting any absentia into consideration. Milord, he won't be working more than, Milord, 150, 160 days in a year. So, Milord, it is 15,000 rupees in any event.
16,000.
Yes, 15 or 16,000. That is what the calculation is all about. Those things are not being shown to your lordship.
Then pain and suffering is very meager. 5,000 is not enough.
Milord, what a bargain counter it has become, Milord.
Not bargaining. This is my submission before the lordship.
Yes, what do you say?
Milord, I have given my answer, Milord. The claimant, Milord, the employer comes up and says it is 100 rupees a day. Milord, the claimant's evidence
is not a salary, daily
basis, Milord. Milord, even if that is, Milord, taken to be true, Milord, he would not in any event be getting more than 15,000 rupees or 16,000 rupees, Milord, per annum. Taking note of the working days of the court when it is open, and Milord, taking note of the absentia.
For argument's sake, if it is
lordship,
taken to be 20,000 also, how much it comes?
Lordship.
At best.
My lord.
জানিয়ে দিতে হবে। হ্যাঁ বলছি ঠিক আছে বলছি হ্যাঁ বলছি
Milord, your lordship will not get into, may I suggest one thing?
Yes.
Your lordship will not get into this calculation. Milord, Supreme Court in so many cases uses the term global compensation. Milord, a lump sum. Make it 1.5 lakh, your lordship will dispose it. I will not trouble your lordship. Milord, otherwise, Milord, Milord, no further amount is to be granted in this particular case. But in any event, Milord, just to get it disposed off, Milord, I, Milord, beseech your lordship, Milord, make it 1.5 lakhs and dispose it off. Milord, I was trying to Milord, save the trouble of your lordship.
Yes, record an order.
Get to tomorrow.
Yes, anything to add? Learned advocates for the parties are present. Are learned advocates for the parties. The appellant before this court was a claimant in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 26/9/2007 passed by learned additional district judge 10th court Alipur in MSCC 14 of 2007. Stop. The case of the claimant before the learned trial court may be summed up thus. Stop. On 3/3/2005, the victim stroke claimant Arif Gaji, while going towards Amtola from Kolkata side by driving motorcycle following the extreme eastern side of Diamond Harbour Road near Duro Company while met with an accident, while driver of offending vehicle number WB-11A2660 was coming from the opposite direction and negligently dashed against the motorcyclist Arif Gaji by going to the wrong side of the road. Stop. As a result, the victim fell down on the road and sustained severe injury and causing permanent disablement. Stop. Pursuant to filing of the claim case, notice was issued upon the opposite parties. Opposite party vehicle owner did not contest the case. Stop. However, the opposite party insurance company contested the case by filing written statement. Stop. Evidence was adduced. Issues were framed and evidence was adduced. Learned trial court, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose the claim case by observing and directing as follows. It is set out here, page 19 থেকে এত অবধি, folded page. The claimant being aggrieved by the quantum of compensation awarded by the learned trial court has come up with the instant appeal. Stop. Third learned advocate for the appellant and learned advocate for the respondent insurance company peruse the evidence adduced and materials on record. Stop. Learned advocate for the appellant submits that the learned trial judge erred in considering the monthly income of the claimant as rupees 15,000 when his employer adduced evidence that he was paying rupees 100 per day. Stop. Learned advocate further submits that the learned trial judge erred in considering the disablement to be 20% when the disability certificate shows that the claimant has suffered 50% disability. Learned advocate also submits that the compensation awarded on account of pain and suffering is also meager. Learned advocates appearing for the respondent insurance company submits that considering the price index in the year 2005, the learned trial judge did not err in considering the annual income to be rupees 15,000. Learned advocate further submits that even if the salary paid by the employer of the victim is accepted, there will not be 30 working days and it cannot be more than rupees 20,000 per month. Stop. It is also submitted by the learned advocate that the claimant was not examined by the medical board with regard to the disability. Upon hearing the learned advocates and considering the facts of the case, although it appears that the learned trial judge could have assessed the monthly income as rupees 20,000 per month and could have assessed further more compensation on account of pain and sufferings and could have applied the multiplier of 18, but instead of proceeding with regard to arithmetical calculation, this court is of the view that it would be just and reasonable to award compensation of rupees 2 lakh to the appellant. Stop. Thus, this appeal, FMA 147 of 2008, stands disposed. The judgment and award dated 26/9/2007, passed by learned additional district judge, 10th Court, Alipur, South 24 Pargana, stands modified to the extent that the claimant appellant will be entitled to compensation of rupees 2 lakh along with interest at the rate of 6% per annum from the date of filing claim case till today. Stop. The respondent insurance company shall deposit rupees 2 lakh along with interest at the rate of 6% before Registrar General High Court, Calcutta within 8 weeks from the date of communication of this order. Stop. In the event compensation awarded by the learned trial court is already paid or deposited, no further deposit be made. The appellant claimant will be entitled to withdraw the compensation upon compliance of necessary formalities.
Your Lordship has given that access, my lord.
Yes.
Instead of 1.5, Your Lordship made it 2.
2.
As my lord, please.
1 lakh 10 to 2.
Lordship.
Much obliged.
Grateful to my lord.
আছে
দেখছি খুঁজছি কিন্তু।
দাও দাও
এই কাগজটা লাগছে না
না আছে আমি নিজে ফাইল করেছি
ও থাক
পলিটিক্যাল আছে
I'm for the appellant, Lordship. Lordship, in the analogous matter, your Lordship has passed this judgment, Lordship. Here the quantum.
No, this is analogous.
Analogous matter has already been disposed of, Lordship.
Same matter.
In this matter, Lordship. Arising out of the same accident, 2 claim cases arose, Lordship. One is injury and is the death case. This is the death case, Lordship. In the injury.
Both are death cases, Your Lordship.
No, this present case. Oriental versus Salma Begum.
Salma.
Lordship.
Your Lordship already decided the other matter.
Other matter,
Due to the want of time, Your Lordship, this matter could not be heard.
Yes,
Your Lordship, the point of challenge of the driving license of the driver of the offending vehicle, but Your Lordship decided that point.
So the principles which I have followed, that has to be followed
Yes, Lordship.
here also.
Lordship, the appeal is filed regarding the quantum, Lordship. In this, Lordship, in this case,
Lordship, I have already prepared one written notes of argument.
You want to prepare a file any written notes?
I've served the copy.
If your Lordship grants me, I will file.
So it's better you file so that I can,
Yes,
instead
your
of hearing.
Only thing, Your Lordship, the income. Already decided the other point. The
Yes,
income.
you give her a copy, so let her
Yes,
file written.
yes.
notes.
Lordship,
Yes,
in this case, actually, twice the future prospect was calculated. Loss of
You give it in your written notes.
We will.
Learned advocates for the parties are present. Hard learned advocates. Let the written notes of arguments filed on behalf of respondents, claimants number 1 to 5 be kept with the record. Learned advocate appearing for the appellant. Insurance company is granted opportunity to file written notes of arguments. Let this matter appear on যে কোনো দিন 4টের সময় দেখুন কবে This Friday can you file?
Next week, any day next week.
Saturday.
Saturday, Sunday, করে দেবো।
Huh? Okay. 11/8/2026 at 4 p.m.
Lordship, there's one application for attainment of majority that should be disposed of. Your
The application
For
filed by respondent number?
Respondent number 4, claimant respondent number 4.
Number 4 for attaining majority, for recording majority stands allowed. Let the majority of respondent number 4 be recorded as per paragraph.
Paragraph 1, Your Lordship.
Paragraph 1 of the application can
number 3 of 26.
3 of 2026. রেখে দিন এটা।
My lord, I am for the appellant, ready for argument.
Yes. Just yes, your matter. Whether I don't know, I cannot say whether it can be taken up or not because anyway. So here both parties are not appearing.
They will definitely not appear, my lord, despite repeated service from your lordship's direction, my lord. I have served on at least 3 to 4 times.
Because I
Lord,
see if I start, it may not be taken up today. I have to fix some other day.
As your lordship pleases, my lord.
Achha, record an order. Learned advocate for the item 12.
Well.
Learned advocate for the appellant is present. No time today. The matter stands adjourned to 12/8/2026.
Lord, 12th August. What can it be on 11th? 12th I have a matter fixed at my lord.
11 তারিখে আছে ফাঁকা দেখুন 11 তারিখে ফাঁকা নেই
3:30 আগে হলে ভালো মিলা নেই I'll not take more than half not
তাহলে
even
13 তারিখ দেখুন
13th my lord
13/8/2026 at 3 p.m.
Great.
My lord, may I start? My lord, page number 82 of the paper book, my lord. That is the fact of the case. That I have filed this case on account of debt sustained by my husband Pramod Das, that my husband used to work as a tailor master in Bangalore. That on 1/6/2023, my husband boarded the train from Bangalore to come home, and I talked to him over phone several times. That he was having work in Tata Nagar, so he went to Tata Nagar first. That on 4/6/2023, my husband went to ticket counter and purchased ticket ex Tata Nagar to Jasidi with valid ticket number 12175768. Ticket was seized by GRPS. He was coming home, and for reaching our house, it is easy to alight at Jasidi station. Next point, that original ticket was handed over to me by proper Zimmanama bond, which I have filed with my claim application. That during the course of working at railway, my husband went to the bathroom. As the doors of the train was open, my husband accidentally fell from the train due to overcrowded passenger sudden jar near Asansol and died on the spot. And the thing is that my house is 161 kilometers far from the place of incident. So because party resides in Bihar, and accident happened in West Bengal, that is in Asansol. So it is 161 kilometers far from the place of incident, his house. Now, to prove my case with my claim application, kindly come to page number 13 of the paper book. 1313. Page number 13 is the ticket, that is Tata Nagar to Jasidi. Ticket has been filed, that is a certified copy, Now, page number 14 is the inquest report, investigation report, which English translation copy has been filed in, in page number 37. That is the English translation copy of the inquest report. In point number 13, it is mentioned, during preliminary investigation and as per the situation and as per the statement of witnesses, it came to be known that this person was traveling by train and fall down from the running train and went under the wheels of the train and died on the spot. So this is the fact which has come in the inquest report, Your Honor. Now, kindly come to page number 17 of the paper book, Your Honor.
Yes.
Page number 17 is the seizure list. Point number 3, from whom seized? From the dead body pocket. An article seized, one railway ticket number 12175768, date of journey 4/6/2023 from Tata Nagar to Jasidi. This is the seizure list, Your Honor. And page number 17 is the post-mortem, my lord. Page number 17 is the post-mortem report.
Tata Nagar to Jasidi.
Tata Nagar to Jasidi, my lord.
No, he fell down in this place.
Asansol, yes. It is between Tata Nagar and Jasidi. Asansol comes here.
Crossing West Bengal.
Crossing West Bengal. Now, page number 17 is the post-mortem report. In
page, not 17, page 18.
Oh, sorry, page 18, my lord. My mistake. Page 18 is the post-mortem report. In post-mortem report, it is mentioned Death was due to the effect of injuries sustained as described above, antemortem in nature. And the injuries are crush injury in abdomen, and these are the injuries which can happen only when the person falls down from the train. Your Honor. Now, page number 19, my lord, is the Zimmanama bond by which he has obtained the original ticket, and that has been filed in the court. I, Urmila Kumari, wife on so and so, in view above, name of article 1, railway ticket number 12175768 from Tatanagar to JCD. This was seized, which she has obtained by Zimmanama bond, and in page number 20, original ticket has been filed. This is Tatanagar to JCD, this same ticket. It was obtained by the party by Zimmanama bond. Now, my lord, page number 21 is the final police report.
Yes.
Final police report, my lord, page number 22, last paragraph. During investigation, neither any foul play could be detected behind the death, nor any complaint has been lodged from any corner of the PS till date. Accordingly, I am submitting final report of this UD case. Death was due to fall down from any unknown running train. Keeping in view, of if any foul play could be surfaced in near future, the case will be reopened. So this is the final report, my lord. And most important thing, my lord, is the railway has given the DRM report, that is page number 51 of the paper book.
Yes.
Page number 51, point number 5, my lord.
Yes.
The railway ticket number UPG 12175768 found from the position of the disease has been verified from Commercial Superintendent Southeastern Railway Tata, in which it is mentioned that the said ticket was issued on 4/6/23 from counter number 3 of Tatanagar booking office. So they have verified the ticket, and it was confirmed that it was purchased from counter number 3 of Tatanagar booking office. And the conclusion of the DRM report is that only the general denial is there, that there is no eyewitness of the incident, so the person has not fallen down from the train. This is the general denial. This is the thing, Your Honor, my lord. And main thing is that
What is the ground of rejection?
Ground of rejection is, my lord, that body was found inside the track and body was cut. So they have believed that it is not a case of fall down, it can be a case of suicide. So this is the thing, only the ground for rejection is that body was found inside the track and body was cut, so it may be a suicide. And regarding...
means inside the two tracks?
Inside the track. Inside the railway track. So only that is the ground. And one more ground is that they are saying that ticket was not found. That is general denial, but that is not so.
Let us see the finding of the tribunal.
Yes, my lord. They have brought the RPF in the court, and RPF is saying that ticket was not found. But that is not at all correct, because, Your Honor, my lord, because in this case, they have filed the DRM report, and in the DRM report, RPF has confirmed that ticket was found from the position of the disease. So this is the most important thing. They have brought a witness in front of the court, and they are saying that no ticket was recovered. Kindly come to page number 52, which is the RPF report of the DRM report, page number 52, my lord. Page number 52 is the RPF report, my lord. In RPF report, it is mentioned, during personal search, found traveling ticket 12175768 ex Tata to JCD and one Aadhaar card number so and so, in which found the identity as Pramod Das.
That is during?
My lord, point number 6, 7th line.
Okay.
During personal search, found traveling ticket number 12175768 ex Tata to JCD and one
Page
Aadhaar.
52.
Page 52, my lord. Page 52, 6th point, 7th line.
Yes.
And Aadhaar card and ticket both were recovered in front of RPF. RPF is saying in the RPF report that ticket and Aadhaar card was recovered. This also was not.
But in the tribunal, they have said that.
Yeah, in the tribunal they have come and they are not admitting that the ticket was found. So this is the thing, Your Honor. In the report, railway report, they have admitted that the ticket was found, and the arts tribunal they have come and they are saying that ticket was not found. They have denied. So this is the ground for dejection, and the body found inside the track and was cut. So that is the ground for dismissal. Regarding that, I will like to file several judgments.
No, let us see the findings. Let us see the findings of the tribunal.
In 86.
86 is judgment is static. Page 86, judgment is static.
This is the challenge.
Yeah.
Yes, 89. Okay, let us come to page 99.
99.
From the photographs provided by the IO of GRP, it is crystal clear that the body of the victim was separated in two parts.
Yes, my lord. That is the main ground for dismissal. So my thing is that if a person is traveling from Tatanagar to JCD and a person is residing in Bihar, so if he has fallen down from the train, then he may go inside the track. So for that, compensation should not be paid. This is not the thing. And body was cut, that is the thing. But if a person falls from the train, it is not necessary that he will always fall outside the track. He can fall inside the track. So regarding that, I will file some judgments, my lord. There is a Supreme Court judgment. I will file that, my lord. And he is not a local resident, that he is residing in West Bengal, so he is a local resident. That is not so. He is residing in Bihar and he was traveling from Tatanagar to Jasiri. That's a long distance train. And his house is 161 kilometers far from the place of residence. And once they have verified the ticket, my lord, and it is verified that it was purchased
You have
from
to see the decision relied upon by the tribunal, whether that decision is applicable to the facts of the case or not.
My lord.
That decision as well as the present facts.
Present facts.
Yes.
I will like to submit some judgments. আমি আপনাকে কপি দিচ্ছি along with my written argument. হ্যাঁ আপনাকে এটা পড়ে আপনাকে দিয়ে দিচ্ছি. Now just after my written argument, the first judgment is Supreme Court judgment of Kamukai. I have underlined the main parts, my lord. Page number 2 of the judgment of Kamukai. The postmortem conducted in the government hospital Karur indicates that the cause of death was due to shock and hemorrhage because of injuries on vital organs and
No, no, page 2
page 2
of your notes.
no,
Oh,
of
page
the
2 of the
Supreme Court
judgment.
judgment, my lord.
Yes.
The postmortem conducted in the government hospital Karur indicates that the cause of death was due to shock and hemorrhage because of injuries on vital organs and decapitation of head. As per the inquest report, the dead body was found with head decapitated at the level of right shoulder. It is stated that if disease had fallen down from running train, his body would not have been found outside the railway track. However, looking to the nature of injuries, as mentioned in postmortem report, the allegation of death of the disease due to untoward incident was denied. Therefore, Southern Railway is not liable to pay any compensation. This was the finding of
No,
the
no,
trial.
this is the stand taken by the authorities.
Yes, Your Honor. Now, what the Supreme Court has found out, that I am saying, Your Honor. This is a stand. That's why I was reading. Now it is, Your Honor, page number 5. It is further urged in the light of judgment of Radha Yadav, because death is proved due to outcome of untoward incident of the disease being bona fide passenger, the adequate amount of compensation may be awarded. Now, page number 6, point number 9. After having heard learned counsel for the parties and on pursuant of provision of Railways Act, in particular chapter 13, which deals with the liability of railway administration for death and injury of two passengers due to accident, section 123 subclause C defines untoward incident. As per clause 2, the accidental falling of any passenger from a train carrying passengers would be an untoward incident. As per section 124A, the railway administration is liable to pay compensation on account of untoward incident when in the course of working a railway an untoward incident occurs, then whether or not there has been any wrongful act, neglect or default on the part of railway administration as such would entitle a passenger who has been injured or died. The claim can be maintained to recover the damages, and notwithstanding anything contained in any other law, the railway is liable to pay compensation as prescribed for such untoward incident. By the explanation of the said section clarifying our passenger, it would include a person who had purchased a valid ticket for traveling by a train carrying passenger on any date or a valid platform ticket and becomes a victim of an untoward incident. So this case was awarded, Your Honor, my lord. Now, my lord, there is another Supreme Court judgment of Rajni, which I have quoted, my lord. This is a latest Supreme Court judgment of 2025, 8 October 2025. Page number 6, my lord.
Yes.
Point number 14. Hence, we reaffirm page 6, point number 14 of Rajni judgment. Now, page 6, paragraph 14. Supreme Court judgment of Rajni, 8 October 2025, my lord.
That is the last one.
No, not last one, my lord. Second one after the Kamukai.
Yes.
Page number 6, point number 14. Hence, we reaffirm that proceeding under section 124A of the Railways Act are not criminal trial, demanding proof beyond reasonable doubt, but welfare statutes are governed by the principle of preponderance and probabilities. Once the
Para
foundation...
15 or page 14?
Page 6, para 14.
Page 6, para 14, yes.
Once the foundation fact of possession of issuance of a valid ticket and occurrence of an accidental fall from the train are established through credible material, the statutory presumption of bona fide travel must operate in favor of the claimant. The railway, as an instrumentality of the state, cannot defeat such claims by pointing to procedural imperfection in investigation or non-examination of formal witnesses. To hold otherwise would erode the beneficial character of the legislation and convert a social justice remedy into a forensic obstacle race. So next point 15 is very important. It is therefore declared that where an official railway inquiry or evidentiary record verifies the issuance of a ticket corresponding to the date and route of an untoward incident. Such verification shall constitute prima facie proof of bona fide travel, shifting the evidentiary burden on the railway administration. The absence of seizure or the inability of the police to preserve physical evidence cannot be itself defeat a legitimate claim when the totality of circumstances support the claimant's version. This principle shall guide all future tribunal and high court in construction section 124A so that the statutory right to compensation remains real, accessible, and constant with a humanitarian purpose of the enactment. So this is the Supreme Court judgment of Rajni. Now, my lord, after this judgment, there is my lord has given the judgment of Kharka Bahadur Chetri. So that is also very important, my lord. Kharka Bahadur Chetri, page number 2, my lord.
Yes.
Learned advocate for the applicant submits that the victim Poojan Chetri was covering a distance of more than 2000 km and was coming with a valid ticket, which was verified by the railway department. Moreover, the place where Poojan Chetri has fallen down from the train is 1000 km away from his residence, so the bona fide and fall both are proved in this case. Now, my lord, page number 3. It is submitted that postmortem report mentions that death was due to injuries accidental in nature, which can only happen if someone falls down from the train. Learned advocate further submits that a station master memo also states that one person was lying inside the track near Wadia. Thus, it is admitted that disease was found in railway area by the railway authority itself. This were the. Now, my lord, come to page number. Page number 10.
Yes.
Before proceeding to decide the material issue, it is to be remembered that railway compensation provision under section 125A of the Railways Act is a beneficial provision. Thus, a liberal approach is to be taken so that the object of the legislation is achieved and not frustrated. The railway authority, which is a state under Article 12 of the Constitution, if upon detailed inquiry and considering police report, has reasonable grounds to behave that it is an untoward incident, should pay the compensation to the victim or his family without relegating them to courts or tribunal for such compensation. In the case of compensation claim before tribunal or court, it is also necessary to consider that in case of death of a person by railway accident in a place far from his residence, it is not possible to arrange for eyewitness. Thus, the applicant has to depend on the report of the police authority, railway authority, and his knowledge of the victim traveling in a train. In the case of SMAT, Yeloma, and others, it is observed it is not possible for the claimants to examine a person as they have witnessed that the deceased had purchased ticket, and also it is not possible for claimants to examine a person as eyewitness to the incident. If any passenger accompanied his friend or relative, then it may be possible to examine that person. But whereas a passenger travels alone along with other stranger passenger, then after the incident and when the claim petition is filed before the tribunal, it is not possible for the claimant to examine any person as witness to the incident. It is not expected in this regard that the claimants to examine any person as eyewitness. Expectation by the railway administration that the claimants should examine eyewitness is ridicule on the part of railway administration, and it is wholly unwarranted. When the railway department prepares report by the divisional railway manager, as stated above, certain duties are prescribed on the railway authorities as per Rule 6 to 13 of Rules 2003. When the respondent railway has taken the contention that the claimant has not produced a railway ticket, but certain duties are cast on the railway as per Rule 4 of Rule 2003. Now, my lord, page number 14. Police authority, it was stated that railway ticket being ticket from Chennai to New Jalpaiguri by ticket number so and so journey issued by CTI South Railway was seized. The police officer first stated that nothing was seized from the position of the victim. Thereafter stated that the victim was identified at the place of occurrence. He also stated that he prepared the final police report and the victim fell down from the train at Wadia railway station. He stated that a ticket was recovered from the pocket of the victim and he prepared a seizure list. Now, my lord, page number 15. As railway compensation legislation is a beneficial legislation, and to allow a compensation claim, it is not necessary to prove the case of untoward incident beyond reasonable doubt. but to show preponderance of probability, the claim can be allowed if from the material on record, the evidence adduced there is probability of untoward incident. Now, my lord, page number 16. During inquiry, the railway ticket which was found from the position of the disease, as mentioned in the seizure list, was verified from DYCCM Southeastern Chennai and learned that the said ticket was issued from booking office. Hence, from the inquiry report of the railway authority, it is established that the railway ticket seized by police authority from the victim was valid railway ticket. As valid railway ticket was found from the position of the victim, it can be concluded that the applicant is able to prove that the death of his son is an untoward incident under section 124A. And so this case was awarded. And my lord, last judgment, that is the latest judgment of Bombay High Court of 10th June 2026. Page number, my lord. Page number 9.
Yes.
The single judge of this court in the judgment of Mr. Sadasiv Rampada Kotian versus Union of India, while considering facts where the body was cut into two pieces, has held that in absence of expert evidence, the tribunal should not have rendered its personal opinion while adjudicating the claim. The contention of the railway could not have been accepted. The tribunal, based on the injury, held that such grievous injury could not be sustained after having fallen down from the train, whereas it needs to be noted the injuries have to be considered in overall circumstances. Paragraph 16 of the judgment read as under. It is also worth mentioning that when a person falls down from the running train, his body will fall away, whereas in this case, the diseased body had been cut into two pieces and was lying in the track. This circumstantial evidence indicates that disease was crossing the railway track and was not run over by the local train. There was no evidence of an expert before the tribunal to opine as to under what circumstances a person's body would cut into two pieces and when it would not. The tribunal should not have rendered its personal opinion while adjudicating the claim under the present statute. Since the provision for compensation in the Railway Act is a beneficial piece of legislation, it should receive liberal and wider interpretation and not narrow and technical one. It should advance the object of statute for, and the single judge of this court in the judgment of Vidya, that is next page, Dhaneshwar Vankhande, held that observation of the tribunal that the death of the disease is not possible by falling from the train merely because he was cut into pieces is completely unjustified and misconceived conclusion. The court further observed that it is not uncommon for a passenger's body to be badly cut or crushed if they fall and become entangled in the train's wheel. In the present case, there was no eyewitness to the incident in the question. The disease was resident of Dhamgamgao district, Amravati. The railway ticket found with disease shows that he had obtained a railway ticket to proceed to Ijapur, which with disease showed that he had obtained district Varda. The railway administration has not adduced any evidence to show that disease attempted to commit suicide. On the contrary, the admission given by the witness examined by the railway administration showed that he had not received any information about suicide or death by any train. Thus, the railway administration has not adduced any evidence to show that disease while crossing the track was dashed by the train and he sustained injuries and his body was cut into pieces. The railway administration has not therefore, the conclusion of the learned member of the tribunal that the nature of injury shows that it is a case of disease coming under the wheels of the train is once again misconceived conclusion because types of injuries along with other facts pertain to decide whether the accident is a fall from the train or injuries were on the account of person being run over by the train. It is not unknown that the body may badly cut up and crush up after falling from the train, either on account of bona fide passenger getting entangled in the place of a train and thereafter in the wheels or the other equipment of the train in which he was traveling, or that the disease on account of fall from the train dashed by various equipment of the railways which are joined to the tracks such as poles, signals, wires. Therefore, in the facts of the present case, the observation of tribunal is set aside. So, my lord, these are the judgments which I am quoting. So, I am concluding my case. So, this is a bona fide case as ticket is admitted, ticket has been verified, and fall is also there, my lord.
These are your written notes also?
Written notes have also been filed, my lord.
Okay. Yes.
Kindly allow me to go through his written notes of argument and judgment.
You submit written notes? Yes. Argue and submit written notes. Learned advocates for the parties are present. Hard learned advocate for the appellant. Hearing on the part of learned advocate for the appellant is concluded. Let this matter appear on
A short date should begin.
11
mile.
11 তারিখে ইয়ে আছে তো দেখুন। Okay, 12/8/2026 for submission of learned advocate for the respondents at 10:30 a.m.
3 p.m. my lord. 3 p.m. 10:30.
Acha, then 12 p.m.
12 p.m.
Okay.
These types of cases are everything untoward incidents were not practically all in favor of the claim.
See, if the railway authority genuinely believes it's an untoward incident, they should not relegate the parties to the court. They should resolve it upon hearing the parties.
Once the judgment shows that once it is in the railway track, everything goes unless.
Why they should be relegated to court? The authority should resolve the matter. Hear them. And they conduct inquiry, they should resolve the matter.
There are other things on in this matter I should do.